Good morning, everyone. I apologize for being a little late. We just ended our caucus to start the day. I'm going to check to see how many committee members we have and then move forward as quickly as we can. Well, it looks like, first of all, good morning. My name is Tom Harnett, and I will be chairing this morning's meeting of the Judiciary Committee. It's very nice to see my colleagues on committee and all of the other folks in attendance for what should be a very informative and critically important morning that we spend discussing the Maine Commission on Indigent Legal Services and how well Maine does or does not serve that population of indigent defendants and persons who can lose major liberties through the judicial system. I'd like to start off by having members of the committee introduce themselves. I will call on you, and I will start with Representative Jeffrey Evangelos.
Good morning, everyone. Representative Jeffrey Evangelos, House District 91, and I reside in Friendship.
Thank you, Representative Evangelos. Representative Libby.
Good morning. Thank you, Mr. Chair. I am Laura Libby. I live in Auburn and represent District 64, which is part of Auburn and all of Minot.
Thank you. Representative Moriarty.
Good morning, all. I hope everybody was safe yesterday. I'm Steve Moriarty from Cumberland. My district includes my hometown in the southern part of Gray.
Thank you. Representative Newell.
Good morning, everyone. Thank you, Mr. Chair. I am Rena Newell, the Passamaquoddy Tribal Representative.
Thank you very much. Representative Poirier.
Thank you, Mr. Chair. My name is Jennifer Poirier, and I represent House District 107, which is all of Skowhegan and a small part of Madison.
Thank you. Representative Sheehan.
Good morning, everyone. Thank you. My name is Erin Sheehan, and I represent House District 12, that is downtown Biddeford.
Thank you. And Senator Keim.
Morning, everyone. My name is Lisa Keim. I proudly represent Senate District 18, which is much of northern Oxford County and 2 communities in Androscoggin.
Senator Sanborn.
Good morning. I'm Heather Sanborn. I represent Senate District 28, which is half of Portland and half of Westbrook.
Thank you. Representative Babbage.
Good morning, everyone. My name is Chris Babbage. I have the privilege of representing the good people of District 8, which is a little more than 4/5 of Kennebunk.
And I'm looking around my screen. I think that is all of the representatives and senators that we have with us right now. We may be joined by others as the meeting moves forward. And I would also like to recognize the people that actually make these things happen. Without them, we would not really be having these committee meetings, and those are our our analyst, Peggy Reinsch, our clerk, Susan Soupy Panett, and our other analyst, Samuel Seneft, who will be joining us probably later when we move on to tribal matters this afternoon. So with that, as I said when I made my opening remarks, today we are going to hear from a lot of folks talking about the way that Maine provides counsel to indigent defendants in both criminal matters and matters that could involve the loss of a child. We are going to hear from, in the first hour, David Carroll from the Sixth Amendment Center, who authored with others the Sixth Amendment Center report that you've all been provided with, which provides a very comprehensive overview of what's going right and what is not going so right. We will also hear from Zach Hayden, an attorney with the ACLU of Maine, who will talk about the constitutional obligations and what agencies or entities like his do if those obligations are not being met. And the last speaker during the first hour will be Rob Ruffner, who provides a lot of criminal defense work for indigents, who will be speaking about his experiences and observations in the trenches. After that, we will hear from representatives of the Maine Commission on Indigent Legal Services, and I will introduce those individuals when we get to that portion of the morning's proceedings. There will be an opportunity to ask questions of all of the people presenting today. With each presenter, I will ask him or her if they would prefer to have questions posed during their presentation or would prefer to have them held until their presentation is completed. I just want to comment that there's been a lot of discussion about indigent legal services in Maine. The Government Oversight Committee had OPEGA analyze the work and the efficiency of the system that we have in Maine. And I just want to point out that there's a couple things that we've been looking at. One is, how are the dollars being spent? That's obviously a very important thing for government, is to make sure that the public fisc is being spent effectively and efficiently. And I do not want to lose sight of that. But I do want to make what might be a personal observation, but one that I want you to keep in mind. To me, the more important issue here is simply whether or not the state of Maine is meeting its constitutional obligations to provide effective defense to indigent defendants in criminal matters and in matters where they could lose custody of a child. This is a sacred obligation of the state of Maine, and it is certainly my intention as co-chair of the Judiciary Committee to make sure that we are doing everything within our power to make sure that the system that we have in place meets the United States and the Maine Constitution. So with that, I would like to introduce David Carroll of the Sixth Amendment Center. Welcome, Mr. Carroll. It's very nice to see you again. Always nicer to see you in the committee room, but you saved a lot of hours of driving today because of this new world in which we find ourselves in. So I would like you to begin, and if you could let the committee know, would you prefer to have questions at the end of your presentation? Is that easier for you to manage?
It is. I put together a few PowerPoint slides to get through a lot of concepts in a relatively quick time. So I think it'll go best if we do the presentation and then take questions.
Thank you very much. Okay, proceed, sir, and welcome.
Thank you. I will share my screen. Great. Thank you again. I am David Carroll, the Executive Director of the Sixth Amendment Center. The 6AC is a nonpartisan, nonprofit organization dedicated solely to ensuring that no person faces potential time in jail or prison without first having the aid of a lawyer with the time, ability, and resources to present an effective defense, as is required under the United States Constitution. We do so by measuring public defense systems against Sixth Amendment case law and established standards of justice. When shortcomings are identified, we help states make their courts fair in ways that promote both public safety and fiscal responsibility. Since our founding, we have been an official right to counsel technical assistance provider under the United States Department of Justice, Bureau of Justice Assistance. Now, I set 3 goals for myself in what I hope you can take away from my presentation. I want to establish the importance of the right to counsel, give a brief history of the right to counsel in Maine, including our report, and propose a roadmap on remedying the right to counsel deficiencies we identified in your state. So on the importance of the right to counsel. Without the aid of an effective lawyer, almost anyone stands the risk of going to jail when charged with a crime. The majority of us would not know, for example, what is and is not admissible in the court of law, let alone how to procedurally convince 12 jurors that the government has not proven its charges beyond a reasonable doubt. If this is true of even the most affluent and educated among us, how can it be fair to let someone who has fallen on hard times or has been let down by our country's educational system face criminal charges alone? How can we accept those who are not yet an adult or are mentally ill or who is a veteran suffering from post-traumatic loss lose their liberty at the hands of government simply because they lack the guiding hand of counsel to navigate the complexities of our legal system? We cannot and never should accept this status quo. As the United States Supreme Court declared in a 1984 case, of all the rights that an accused person has, the right to be represented by counsel is by far the most pervasive, for it affects his ability to assert any other rights he may have. Now, 1 month from now, our country will celebrate the 58th anniversary of Gideon versus Wainwright. In Gideon, the US Supreme Court said, the right to a lawyer is an obvious truth. In establishing that the 6th and 14th Amendments to the US Constitution obligate states to provide effective representation to the indigent accused. Failing to properly implement Gideon and its progeny results in two problems. First, people who are often adjudicated guilty and incarcerated are so done without ever speaking to an attorney. Secondly, the accused often is appointed an attorney who is unqualified, unsupervised, and/or financially conflicted, and who often carries an excessive number of cases such that the defendant receives little to no representation at all. Such systemic deficiencies impair the accused's ability to receive due process and a fair trial, while frequently subjecting taxpayers to unnecessary expenses caused by over-incarceration, wrongful convictions, and systemic litigation. There is simply no greater tyranny than state government taking a person's liberty without the process being fair. Deficient indigent defense services produce a myriad of seemingly disconnected problems throughout the greater criminal justice system. For example, why do convicted persons have difficulty re-entering society upon release from prison? They do so in part because their public advocates are prevented many times from continuing to fight on their behalf for better conditions of confinement and treatment and re-entry programs after they are incarcerated. Why is the United States one of the few countries in the world that still relies on cash bail? The answer is that many states do not appoint counsel at bail hearings. Point to almost any criminal justice issue, and the root problem will be a lack of true advocacy on the part of people of insufficient means charged with a crime. Just as a doctor treating only the visible signs of an underlying ailment may fail the patient, attempting to address the countless issues plaguing criminal justice without concurrently reforming indigent defense services will result in half measures and unsustainable policies. Okay, I will step back now and turn to Maine specifically. In the wake of the Gideon decision in 1963, Maine initially left the majority of funding and oversight of indigent defense services to its counties. And since the moment of that decision, Maine has struggled to fulfill its constitutional mandate under Gideon. Indeed, as this slide shows, in study after study, independent evaluators questioned the manner in which Maine administered the right to counsel. In '65, the Maine Judicial Council expressed dissatisfaction with the functioning of the assigned counsel system, noting the lack of uniformity between counties based on disparate levels of justice. Basically, the level of justice received was potentially based on which side of a county line the crime was alleged to have been committed. In '71, the Institute of Judicial Administration concluded that there is not much confidence that the assigned counsel system is working well. In 1976, Maine finally took over 100% responsibility for funding indigent legal services, but left the oversight of the attorneys providing services as a court function, with judges maintaining lists of private attorneys willing to take cases and individually appointing lawyers to cases. Such judicially controlled systems are prohibited under national standards because they create a conflict of interest between the financial interests of the lawyer and the legal interests of his client, as attorneys may do what they think is needed to please the judge to secure future appointments, rather than advocating in the sole interests of the defendant. Studies continued to find fault until the creation of the Maine Commission of Indigent Legal Services in 2019. Since its inception, MCILS has never used governmentally employed attorneys to provide representation, commonly called public defenders. Instead, MCILS pays private attorneys $60 per hour. Let me be clear about this. Maine is the only state in the country that provides all indigent defense services through private attorneys. There are two principal reasons why other states have moved away from using private attorneys to provide indigent defense services. Maine has struggled with both of these reasons. First, it is difficult to protect and contain costs in private attorney systems. A system can certainly estimate future caseloads based on prior year trends and apply average estimated cost per case by case type to calculate what funding should be required to deliver the mandated services. But there is no guarantee that past averages will continue to apply to future years. MCILS has historically had to come back to the legislature for supplemental funding. Second, it is simply extremely difficult to supervise private attorneys to ensure that they can and do provide effective representation to the poor. In 2017, the Maine legislature created the working group to improve the provision of indigent legal services to address such of the issues that were found in past reports. They found that MCILS does not have systemic oversight of evaluations of attorneys, and it is in need of stronger fiscal management, and recommended undergoing an outside, independent, nonpartisan study of Maine's current system. And that's where the Sixth Amendment Center comes in. In March of 2018, the Maine Legislative Council contracted with us to evaluate right to counsel services and chose 5 sample counties for us to study. We never pick the counties to be studied. We don't want to be accused of cherry picking either the very best or the very worst that a state has to offer. And we wanted an official body choosing those sample counties so the people of the state would recognize it as being a reflective sample. The 5 counties we studied was Androscoggin, Aroostook, Cumberland, Somerset, and York. The 6IC analyzed data, conducted courtroom observations, and interviewed criminal justice stakeholders. Now, we ended up producing a 105-page report. We managed to stuff in there 355 footnotes, documenting in great detail the deficient provision of legal services to your state's poor. Whenever we do this type of report, we like to do this encyclopedic approach as a reference guide to leave for future people looking at this issue. So for instance, should the legislature want to in the future consider going back to some type of flat fee contract payment, as was existing in Somerset County at the time of our study, all the evidence is there in our report why such a decision would be unwise. So, having said that, I don't want to make everyone read a dense 105-page report with 355 footnotes. So I boiled everything down to a single slide. This is what you need to know about your system. The state of Maine expects MCILS to maintain both quality and financial oversight of nearly 600 attorneys handling more than 30,000 cases in 47 courthouses, presided over by approximately 90 judges, justices, and magistrates, with a staff of 3 people. Let me say that again. 3 people were expected to keep both financial oversight and quality oversight over 600 attorneys carrying 30,000 cases. It simply cannot be done. Given this fact, it should not be surprising that we found significant issues in both the quality and financial oversight of your indigent defense services. For example, MCILS attorney qualification standards are way too lenient, resulting in an excessive number of attorneys taking cases. Many of those attorneys lack training and supervision. Under MCILS qualification requirements at the time of our study, an attorney who graduated law school 2 years ago hung out their shingle in a private practice with no supervision or training and can have 2 jury trials and 2 judge trials, and then they can be appointed to represent indigent defendants in almost every type of case short of homicide or serious sexual assaults. Perhaps more worrisome is that indigent defendants charged with Class E crimes, which carry up to 6 months of a loss of liberty in jail, can be represented by an attorney who has just received their bar card and completed a single training course in criminal law, as long as that attorney has an email address, a phone number, and a space to meet clients. These are extremely low attorney qualification standards. Throughout our report, and I won't get into it here, we contrast that with some of your neighboring states, most specifically Massachusetts, about the stringent requirements to get onto a panel. In your state, we found that some prosecutors in some jurisdictions engage in plea discussions directly with uncounseled defendants, and some courts actively encourage such negotiations, resulting in the actual denial of counsel. Now, there's many reasons for why this happens, but it's almost exclusively due to excessive caseloads for attorneys. In every courtroom observed, in all the sample counties, the same video is played before the judge on the bench, enumerating defendants' rights. Yet no one ensures that the defendant has watched the video, understood the language spoken in the video, or have the mental capacity to understand that video. And it is often the case that tardy defendants enter without ever seeing the video at all. And so they proceed to talk to prosecutors and enter into plea deals. Moreover, under US Supreme Court law, a plea negotiation is a critical stage of a case. This means that the negotiation cannot happen unless counsel is present or the defendant has waived the right to counsel both knowingly, voluntarily, and intelligently. And again, despite this, throughout sample counties, we saw prosecutors talking to uncounseled defendants. Now, interestingly, coming into this study, I sort of half expected the major issues to occur in the most rural counties in the north of Maine. Instead, the actual denial of counsel problems were most prevalent in the South, where large court populations and not enough assigned counsel attorneys being present in court exacerbated this problem. Despite there being many excellent lawyers throughout your state, there are also too many lawyers who do not perform adequately, and the state does not know the difference between the two. In one of the studied counties, the sheriff, due to the volume of prisoner complaints, that about 25% of assigned counsel attorneys do not visit their clients in jail to prepare their cases. He was also concerned that attorneys not accepted calls from the jail. He said that prisoners stopped calling when their calls were not accepted. Consistent with that report, one judge estimated that 25% of attorneys have not met with their clients before their first dispositional conference date, and that up to 10% of attorneys withdraw or become a second chair if the case goes to trial. Now, MCILS data trends to confirm these observations of the sheriffs. For example, our organization requested 3 years of data on jail visits on cases billed out of Cumberland County. The data revealed a number of attorneys that often visit clients, but a concerning number of attorneys do not. For example, in 2017, one attorney billed MCILS about $112,000 for all cases arising out of Cumberland County, including just over $3,000 to perform 96 jail visits. But by contrast, another attorney billed MCILS about $172,000 and did not bill for even a single jail visit during that time. Now, certainly it's possible, though I must say unlikely, that the attorney simply decided it was not worth the time to bill jail visits. But the point is that MCILS, and therefore the state of Maine, does not know because of this overwhelming lack of oversight of the system. What became even more troubling over the course of our study is the fact that MCILS does not exert adequate financial oversight of private attorneys. A significant number of attorneys billed in excess of 8 hours per day, 5 days a week, for 52 weeks a year without ever taking a day off or having a single hour of non-billable expenses. Now, we've heard a lot about overbilling in the press and in prior legislative hearings. It was a topic that was frequently raised throughout your state. At the time of our study, attorneys did not submit vouchers under penalty of perjury, which is unusual for most state indigent defense systems. No statutes or MCILS rules limited attorney hours by day and by year. MCILS conducted no audits. Not surprisingly, a review of the vouchers over the past 5 years generated serious concerns in some instances about whether limited taxpayer resources were being used efficiently. Let me make this clear. If an attorney works 8 hours per day, 5 days per week for 52 weeks a year and bills every single one of those hours, an attorney should not be able to make more than $124,800 per year at the current $60 per hour MCILS rate. Yet in 2018, 25 attorneys billed MCILS in excess of 40 hours per week. The top biller in 2018 billed more than 88 hours per week. As part of this review, the 6AC reached out to the Federal Defender Services on the Administrative Office of the U.S. Court. The Federal Defender Services confirmed that 8 of these 25 lawyers also received federal appointments during this same period. That really questions the ability of whether MCILS is performing any financial oversight whatsoever. Now, as I told previous committees, I may not be a taxpayer of Maine, but I do feel that I have contributed heavily to the economy of your state by sending my 2 girls to overnight summer camp in Maine each year for the past 7 years. And it just simply irritates me that Maine does not have any financial oversight of the dollars that are spent on the state's constitutional obligation to provide counsel. To be clear, the 6AC was in receipt of MCILS data for 1 day when it became clear that there was these problems with these attorneys. We immediately informed the Judiciary Committee chair that there was this problem well in advance to finishing the report. Now, what I want to say is we use these top earners to more readily show the problem and demonstrate it to you. But here's your bigger problem. MCILS, and therefore the state of Maine, also has no idea whether the attorney who billed only $20,000 per year performed adequately and properly billed on those too. We simply showed you the most egregious example of how you do not have control, but you don't have any oversight over any of this. Now, The Sixth Amendment Center did not have the ability nor the authority to go further than that sort of overview on this billing problem. However, Maine's Office of Program Evaluation and Government Accountability did, and OPEGA confirmed exactly what the 6AC found. They said, among other things, that there are no established policies and procedures governing expenditures and payments. Current monitoring efforts of attorney vouchers are inefficient and of limited effectiveness. Auditor review procedures have not been established, and current audit efforts are limited, inconsistent, of limited scope, depth, and effectiveness. And MCILS is understaffed and receives insufficient support for necessary operations. It is my understanding that OPEGA is still studying the quality issue, but I can tell you that the answer will be the same as it was on the financial oversight, and concur with the 6AC that there is inadequate oversight when you provide only 3 people to do all this work. So let's talk about where we go from here. Although the 6AC made a number of recommendations, all of which I'm more than happy to speak about with you all in the future, there is one major deficiency in your right to counsel system that should be addressed. We say in our report, the state of Maine should authorize and fund MCILS at an appropriate level to employ state government attorneys and support staff to operate both a state appellate defender office and a trial level office in Cumberland County. Providing oversight of all private attorney systems is the most extremely difficult way of trying to do it. Creating public defender offices allows for built-in supervision, much like you have currently in your prosecutor's offices. MCILS does not currently have the statutory authority to establish governmentally employed public defender offices. The relevant part of your statute states, the commission shall develop and maintain a system that uses appointed private attorneys, contracts, and individual attorneys or groups of attorneys, and may consider other programs necessary to provide quality and efficient indigent legal services, but it does not overtly give them the power to propose public defender offices and seek that funding. In short, the statute needs to be amended to give MCILS express authority to create public defender offices. Now, the Sixth Amendment Center does not presume that Cumberland County is the only jurisdiction in your state best served by a trial level public defender office. It is just that the one that will give the state financial and quality oversight in the greatest number of cases, easing your problems the quickest. As a side note, the American Bar Association standards say that a state should have a public defender office wherever caseload justifies it, and that would be Cumberland County. Now, we recommend in Cumberland County only because we did not directly study the other counties that appear from caseload data to justify a public defender offices. MCILS and Maine policymakers should consider expanding public defender offices to Kennebec and Penobscot counties as well, once the state appellate defender office and the Cumberland County office is up and running. We did not go to Kennebec and Penobscot County. We think it's unfair to comment on those counties without having sat and talked to the people of those counties. But we're pointing out that we really do think that if MCILS has the authority to do so, that those would be the next 2 that should be brought online. Now, here's the interesting fact for you all. As far back as 1971, one of those early studies that I mentioned, the Institute of Judicial Administration, the Maine Supreme Judicial Court, and the Superior Court of the State of Maine recommended precisely this approach. They said the state should fund a hybrid public defender private attorney system with public defender offices situated in Portland, Augusta, and Bangor. So yes, that's right. Your own state research came up with the answers as far back as 1971 that meets with what we're suggesting for you. Let me state for the record that we struggled with the budget for an expanded MCILS, a state appellate defender, and a Cumberland County Public Defender office. Whenever we attempt to do such budget projections, we often look to prosecutors since the ABA calls for parity of salaries, benefits, and others between the prosecution and the defense function. And the ABA standards say you should do this assuming that the prosecution is adequately funded. Now, I want to be clear before I say this. The Sixth Amendment Center is not experts in the prosecution function. That said, I have personally traveled throughout the country, been to 49 states, and our other experts on our team have observed and spoken to many district attorneys across the country. It appears to us that the prosecution function in Maine is also under-resourced in regards to attorney salaries. Several prosecutors spoke to us about their own low compensation, especially in regards to the payments being received by private attorneys and their own high caseloads. We were struck with the care in which your prosecutors spoke to us about the indigent defense problems in your own state. And I promised to them that I would raise this observation about compensation of prosecutors wherever appropriate. And I deem this hearing appropriate. Now, going back to the indigent defense side, creating a state appellate defender office, as well as trial level public defender offices, certainly in Cumberland, but perhaps also in Kennebec and Penobscot counties, will decrease the reliance on the private bar attorneys. MCILS could also increase the attorney qualification standards for private counsel, and thus significantly reducing the number of attorneys providing indigent defense services. The reduction of the private bar will then justify our next recommendation. The state of Maine should fund MCILS at a level that allows private attorneys to be compensated for overhead expenses plus a reasonable fee. We projected that at $100 per hour. MCILS should also be authorized to provide additional compensation of $25 per hour for designated cases such as murder or serious sexual assaults or post-conviction review that takes really the most intricate type of representation. Now, to give you an idea of where that falls nationally, the MCILS current $60 per hour compensation rate is, in our estimation, inadequate to both cover private attorneys' overhead and provide that attorney with an adequate, reasonable fee. As a comparison, the South Dakota Supreme Court set public compensation hourly rates at $67 per hour in the year 2000. To ensure that attorneys are perpetually paid a reasonable fee and overhead expenses as is required, the court also mandated that court-appointed attorney fees will increase annually in an amount equal to the cost of living increase that state employees receive each year. What that means is that assigned counsel compensation in South Dakota now stands at $99 per hour. Considering the cost of living of the two states, a comparison between South Dakota and Maine would mean that Maine should be paying $120 an hour fee to be on the same par as South Dakota. Now, I have one more thought for you all that was not expressly recommended in our report, but that has become abundantly clear since the publication. The director of MCILS is a critical position to the overall health, certainly of the indigent defense system, but to Maine's overall criminal justice system. Given the pandemic and Maine being viewed nationally as an ideal location for work-life balance, many people have called me interested in the position. But in my opinion, two things are reducing applications for that position. The first is that the salary being offered is far too low, especially given all the deficiencies the next director is expected to fix. The second is that there have been media reports saying that MCILS will not receive more funding until it fixes itself. So the combination of a low salary, big problems, and public reports that policymakers are considering not giving any more money to fix these problems is decreasing the number of people that want to apply. A public defender should be the voice of the poor people on criminal justice issues in your state. And that person should be actively involved at all levels of conversations on criminal justice matters. Now, in conclusion, I don't want to leave the impression that the only answer to indigent defense reform in Maine is to simply throw money at the problem. The right to counsel is only required when there is a threat of jail and a loss of liberty. If the state looked to increase diversion options, reclassify certain low-level crimes to violations, you could shrink the size of the criminal justice system altogether, thus reducing the need for indigent defense services. The Sixth Amendment Center is only cares that whoever requires the right to counsel receives effective services. If that is one person, then that's all you need to do to provide services. So there are options beyond just more money, more money, more money. But until that happens, you do have to fix your indigent defense services, because I believe that they are currently unconstitutional and that there is you have exposure if anyone was looking to do systemic litigation. Thank you very much for listening intently. I know that was a lot of information, but I'm happy to take questions.
Thank you very much, Mr. Carroll. That was quite a report, and having read the full report, it's amazing you were able to do it in that period of time. Before opening it up to questions, just a couple of housekeeping matters. One, I appreciated that everyone did mute their phones because it makes a big difference. Two, I would hope, Mr. Carroll, that you will be able to provide that PowerPoint so members of the committee can view that again. Thank you. And the third is we were joined by another representative who I would like to have introduce herself, Representative Lois Reckitt. Representative Reckitt. Perhaps she has left us again. I apologize. And I failed to formally introduce myself at the beginning. And my name is Tom Harnett. I represent House District 83, which is the town of Farmingdale and the city of Gardner. I'm going to open it up to questions now for Mr. Carroll, and I believe that I have the order correctly. The first question will be from Representative Babbage.
Thank you, Mr. Chairman. I appreciate it. And good morning, Mr. Carroll. And I'm a great admirer of your work generally and for us. And I appreciate this data and recommendations. I wanted to ask, first of all, you talked about the oversight being a court function and a conflict of interest with federal standards. Can you be more precise about that? It's not technically illegal, but what standards are we talking about?
So the American Bar Association standards requires the independence of the defense function. There has been dicta throughout US Supreme Court cases on the problems that arise when judges are directly controlling the oversight of indigent defense services.
And I have just three short ones, I believe, Mr. Chair, if that's okay. The second one is, yes, some eyebrows were raised when we looked at the billing in 10-minute increments that amounted to some very large six-figure, awards in payment to attorneys. Did we ever distinguish whether individual attorneys from firms billing? In other words, does it challenge all credulity, or could the billing have been for multiple attorneys?
That's certainly one of the findings in the OPEGA report, is that some of that explains some of that. But I think the bottom line, certainly from our point of view, is that you do not have the guardrails in place to go back and try to figure out which are which and which could possibly be fraudulent billings. Great.
Yeah, thank you. And the last thing I wanted to mention, just to clarify Maine's position, we have this unique system that has existed for some time now, actually. The opposition to the flat fee contract in Somerset, did it have to do with the rationing of justice? Is this, I guess what I want to ask is, when you are visiting other states who have public defender systems, do those situations result in a criticism of the delivery of justice because of underfunding and therefore a rationing of justice? Is that similar, or could you clarify that for me?
Sure. There are many states who are struggling with these same issues that you are. There are another set of states that more readily meet Gideon's promise and do it effectively. So what we often say is we're less concerned with the delivery model, whether it's private attorneys or public defenders, because if you have poorly funded public defender offices, they can be just as problematic, and you might have read about some of those problems across the country. But what I can say is providing proper oversight, both of the services and of the vouchers, is much more difficult and costly in private assigned counsel systems. So my own home state, Massachusetts, is one that relies extensively on private counsel as well. And I believe our population is about 5 times the size of Maine. So for comparisons, if you're spending, let's say, roughly $20 million, you would spend about $100 million on indigent defense if you wanted to have a system similar to Massachusetts. Massachusetts currently is spending $272 million on indigent defense services, but it's recognized that they're providing proper oversight of the private bar. You could point to other states, Colorado and Oregon, that also rely exclusively on private bar attorneys. Oregon in Colorado has public defenders for primary services and private attorneys for conflict services. Oregon, Colorado, Massachusetts are all in the top 5 cost per capita spending on indigent defense. So public defense services provide a more efficient way of providing oversight and getting control of finances, but it doesn't mean you couldn't have quality services with a private system. I just think our recommendation to you is, because of all the problems that you've had in the past, a state appellate defender provides a check against trial level services, so that's a good use. And then Cumberland will quickly take care of a lot of the problems of oversight because of the sheer number of cases there, and then look to Kennebec and Penobscot. Finally, I want to say one other thing, because I've had people raise it before. It doesn't mean public defenders are not potentially effective in more rural areas. And one of the great pleasures of my job is going to places a lot of people don't. So I personally took going up to Aroostook County to get to see it and get to know it. The number of cases there are so low that you could probably only support maybe a 2 or 3 public defender office, and that may not necessarily be worthwhile. However, you might attract attorneys that want to live there knowing that they have a secured salary. We've seen many states that have taken this approach and say, you know, attorneys don't want to go up there and have to get only a few criminal cases, go after, you know, estate cases and divorce cases and personal injury cases. If they know they can come up there and be a public defender, they're more likely to do it. But that's so far down in the weeds for us to be able to do that. But you do want MCILS authorized to make those decisions and present them to you and say, yes, Aroostook County also should have a public defender office. So we pride ourselves in not overstepping and going further than what's been asked of us so that we are assured of what we're recommending to you. But MCILS absolutely should have that authority to make those decisions and present to you an appropriate budget to make that happen.
I appreciate that answer. Thank you, Mr. Carroll. Thank you, Mr. Chairman.
Thank you, Representative Babich. And just so folks are prepared, the order of questioning that I have moving forward is Senator Keim, then Representative Evangelos, then Representative Moriarty. Senator Keim.
Thank you. Good to see you again, Mr. Carroll. I never expected that you'd be joining us year after year in the Judiciary Committee. Eventually, we're going to make changes and, you know, you'll move on to another state. A couple of questions, and then I'll just let you answer both. I'll give you them both and let you answer. Would you talk to us about moving the screeners outside of Indigent Legal Services? And I guess we're thinking that would go to the courts, and how would that look? And do you have any suggestions around that? And then I think we had a bill last year to just basically say there cannot be, that would make it illegal for there to be uncounseled defendants. I'm not really sure what happened with that, but is that the simplest route? We just say that's, against the law and do that, or is there something I'm missing here on that aspect? And
Sure.
that's my two questions. Thank you.
Thank you. So on the first one, public defenders or public defender employees doing the screening tends to not be the best way of doing that. Public defenders often have an affinity towards the clients. They want to try to get them as much representation as possible. And there's also there's those type of conflicts. Ideally, and this is a concept that will be new to Maine, but many of the better states has a government function called pretrial services, where neither the court nor the public defenders are doing those screenings. It's a group that's making just objective calls. They often do things like screen the people for whether they should be detained in jail pre-trial and things like that too. They'll often present to both the prosecution, the court, and public defenders recommendations on bail and all sorts of things. That ideally is the best place because it's the most objective place for people to be screened. But I know that is talking about creating a whole new level of government in Maine. So barring that, since it's ultimately the court that makes the decision on whether someone gets an attorney or not, it is usually less problematic for the court to be doing that function. And on the question of uncounseled representation, I think there's a couple fixes. We certainly said, a statute saying that it's unconstitutional anyways, you won't have any challenges, is something that would be done. But even if you had that statute, there's then how do you get it to be implemented and filtered on down? And I remember we had one legislative hearing last year where the prosecutor in Cumberland County offered some really concerning issues as far as how to do some of the pretrial stuff and diversion they were hoping to do. And I think that's a legitimate debate. But the way around that is simply to appoint MCILS the second that somebody is found indigent, so that nothing happens without the person having an attorney at the get-go. That would, in my opinion, resolve the issues that were raised in Cumberland County to do that.
Thank you, Senator Keim. Does that take care of your questions? Thank you. Representative Evangelos.
Thank you, Matt, Mr. Chair. And welcome again, Mr. Carroll. Nice to see you again. Sorry to see you under these circumstances. The report I'm looking at is dated April of 2019, but we have made some progress. There's been a new executive director appointed, and we have some very committed commissioners. So I just wanted to raise a couple of concerns and questions. Since we first and last talked to you, we had some news stories here that attorney client conversations in some of our county jails were being recorded and shared with prosecutors. Were you aware of that?
Not at the time of our study, but I have read the press reports that you referenced.
Do you have any comment?
Well, this is precisely the type of things that happen when you don't have a functioning indigent defense system. If you had a chief public defender or the executive director of MCILS doing the types of things that those positions traditionally do in other states, they may be bringing lawsuits about these issues. They may be talking to sheriffs and prosecutors when it's revealed. You have, so much put on MCILS just to sort of do the basic functioning that they haven't been a great voice for policy change, in my opinion, across the state. So those are the type of things that you would snuff out earlier if you had a functioning indigent defense system.
Thank you. Recently, our excuse me, our chief executive weighed in on our indigent legal issues and indicated that she probably wasn't going to be supportive of any financial resources until we solved our problems. But I don't think we can solve our problems without the financial resources. So do you believe that we can solve our problems with not investing some money?
No.
Thank you. Last question. You were very helpful to the Judiciary Committee last year, last summer, when we heard the post-conviction review bill. And this does relate to indigent legal because some of our indigent defendants who are incarcerated have to obtain an attorney. But I wanted to just run by you that when we've tried to assert these reforms in the legislature, representatives of the judicial system routinely show up, and while they may say they're testifying neither for nor against the bill, they raise questions about, well, our court system doesn't have the resources. So I just want to run this by you because this is the systemic biases that we're confronting in Maine in our criminal justice system. We've got the resources to arrest them. We've got the resources to charge and indict them. We've got the resources to try them. We've got the resources to convict them. And we've got the $50,000 of resources a year to incarcerate them. But we have no resources to constitutionally represent them. And we have no resources to free them from prison when they're innocent.
Mm-hmm.
That pretty well describes the challenges I've encountered when I've introduced these reform bills. Do you think that's an accurate summation of our situation here?
I do. And oftentimes when I do legislative hearings like this, I'll do a whole thing on the history of the right to counsel, how it was created, how it was formed. And it's important to realize defense counsel were being appointed to cases long before there was professional prosecutors and police systems in our country. It was defense attorneys that created the uniquely American adversarial justice system. And the founders of our nation included, almost all of the Bill of Rights is about due process for people whose liberty is being taken away. What you just described, sir, is to me the definition of tyranny. The government has the resources to arrest, to prosecute, to put in jail. But if you're not giving them the resources to mount a fair defense, then you're simply putting people in jail without bothering to realize whether you've got the correct person or not. And if, an innocent person is in jail because the state hasn't taken the time to do it right, the real perpetrator of the crime may very well still be on the street causing havoc. So it's really, really important that Maine gets this right for precisely that reason that you've mentioned.
Okay, just a final follow-up, Mr. Chair, if I may.
Yes.
Thank you. We're going to be hearing some very significant criminal justice reform bills in the coming session. Hopefully, we'll get back to work in person and we can get back up to speed. But in the event, whether it's in person or it's a hybrid model or we continue to communicate this way, I feel personally it's very important to have your involvement and your testimony and your input on these bills, either at the work session or as a matter of testimony. Are you registered with our committee clerk to be receiving notice of these bills?
I don't know if I'm officially, Peggy Reinsch is great about notifying me, but I will sign up to be officially notified if that's what's necessary.
Well, yeah, I don't want us to miss any. So you're a fantastic resource for us, sir. And thank you for your work. We're trying. I want you to know we're trying, but we have to invest. And I'll also speak to the committee clerk and make sure you're tied in, because your information that you provided us last summer on LD 302 regarding the Massachusetts Criminal Code, the right to an appeal when new evidence surfaces was critical information that led the committee to vote out to pass on that bill. So we need you. We'll work on that. Okay.
Thank you, Representative Evangelos. The last person I have with questions for Mr. Carroll before we move on to our next presenter is Representative Moriarty.
Thank you, Mr. Chair. Good morning, Mr. Carroll.
Good morning.
Just by way of quick background, I became a member of the bar 42.5 years ago. And in the early years, I did a lot of court-appointed work at the rate of $40 an hour. Clearly, the rate has not kept pace with inflation in the years since, and you're right on in terms of the increase that needs to be made with respect to the rate. But two quick questions. You have made multiple references in your report to the possibility of jail time and also in your comments this morning. And we know that any type of conduct defined as a crime carries with it the risk of incarceration. The question is that for our two least serious types of criminal offenses, the class D and E offenses, in fact, how many of those convicted end up with sentences of incarceration?
I don't have those numbers offhand. I'd be happy to get those, but I think generally, that there's a decent percentage of them going to jail. I'll tell you one quick story. At the time of our study, the legislature had made the determination that they would decriminalize driving with a suspended license, but it wasn't going to take effect till after our report or site visit work was done. But everyone knew that was the intent. In courtroom after courtroom, and I have a visual memory of this up in Aroostook County, almost everything we were seeing one morning was driving with suspended license cases with the threat of jail and some people going to jail for it. So it does occur. I can't tell you the exact percentages, but that's an education problem too, is when the intent is to decriminalize or reclassify something, people need to know that that is the intent so that they stop bringing those types of cases.
Yeah, exactly. And just one more question. In your report, you made the point about there needs to be continuity of representation, and you were critical of the so-called Lawyer of the Day program, which I'm not actually personally familiar with. I take it it's largely someone who serves as almost a traffic cop in district court, I assume, where there's a high volume of offenders and arraignments and initial appearances. What's the substitute for the Lawyer of the Day? And does it make sense that that person becomes the accused attorneys from that point forward, that he or she first offers a little bit of advice in the midst of a crowded courtroom to the end of the case?
Right. So that is the ideal. And there's two ways to do it. First of all, if you have a staff government public defender office, right, they can schedule people to go down to the courthouse each day, and what cases they pick up, those become their cases indefinitely all the way through to the end, unless there's a real conflict occurs. But this can also happen with assigned counsel systems. Again, not to be a homer and just emphasize Massachusetts, but it's the one I know best. They rely on assigned counsel attorneys to do most of those non-serious crimes, but they schedule a bunch of people to go to each court. And when they catch cases, those are their cases to then run. That's how they catch their cases. That's how their assignments are done. It takes a lot more work, but it can be done. Maine has just opted to say, we'll give you some money, just go down there and, as you say, be a traffic cop. And I should say in Cumberland County, they don't put enough traffic cops there. So we saw attorneys of the day trying to serve 60, 70 people each morning. There's no way people are getting decent legal advice on what they should do at that early point in the case with those kinds of numbers.
Yeah, I guess that's why I'm wondering how the lawyer of the day could simultaneously direct traffic while serving the initial legal needs of as many as 60 people per day.
So instead of having 2 lawyers or 3 lawyers of the day, you would schedule, 15 lawyers to go down there, and each of them would catch 4 cases.
Okay. Thank you.
Thank you, Representative Moriarty. I see no other hands up right now, so I want to thank you again, Mr. Carroll. Hope you can stay around with us.
I'm happy to do so.
Thank you. And as others have said, it's always a pleasure to see you. The next presenter will be Zach Hayden from the ACLU of Maine, and I think it worked well to let the presentation go forward and hold questions to the end, so I'm going to stick with that model. Good morning, Zach.
Good morning. Good morning, Representative Arnett and members of the Joint Standing Committee on Judiciary. Thank you so much for the opportunity to speak with you this morning. My name is Zachary Hayden. I'm Chief Counsel at the ACLU of Maine. I hope that you can all hear me, and I'm sorry that we can't all be together at the State House. I don't want to repeat the excellent comments that my friend Mr. Carroll made or the comments that his organization made in its report. I do have a few remarks, but I will try to keep it brief so that I can address any questions that the committee might have. At the ACLU, and I think most of you, we've worked together, many of you, for many years, and you're aware of this, but I'll just say it for the benefit of those of you who we haven't worked with yet, who may be new in the legislature. It has always been our practice to try to work through non-litigation avenues to address problems. And that's true even when fundamental constitutional rights are at stake. You have seen me, my colleagues at the legislature, Megan Sway and Michael Cabete, spending many hours trying to work with the legislature and with administrative bodies to address problems. We are not and have never been an organization that rushes off to court anytime that we believe that the Constitution, there are constitutional rights that have been impacted or implicated. And since the Sixth Amendment Center report was issued almost 2 years ago, we've made a commitment to participate in any discussion before this committee or the Maine Commission on Indigent Legal Services where problems or solutions to those problems are being discussed. We've devoted an enormous amount of time to trying to encourage the state to address these problems and to help develop solutions. But I will tell you all on behalf of the ACLU of Maine that at this point, we are concerned that this non-litigation path that we have devoted so much energy to is not getting the job done. The state has an obligation to guarantee the assistance of counsel to people who are accused of crimes and threatened with the loss of liberty. That obligation is rooted in the federal Constitution, the Maine state Constitution, statutes enacted by the legislature. And I believe, consistent with what you just heard from Mr. Carroll, that it would be an exaggeration to say that Maine has an inadequate system for assuring that the lawyers appointed to represent people have the training, the supervision, and the resources they need to get the job done. Maine's system is not inadequate. Maine's system is non-existent. 2 years ago, Maine judges acknowledged to the Sixth Amendment Center in response to their investigation that the legislature hired the Sixth Amendment Center to conduct, that there are lawyers practicing in the state who do not meet with their clients regularly, who do not engage in informed advocacy on behalf of their clients, and who should not be allowed to represent clients. Some of those lawyers undoubtedly could do a better job if they had access to meaningful training. But the state still does not provide meaningful training for those lawyers. And some of those lawyers are undoubtedly not fit for criminal defense work. But the state still has no mechanism for evaluating attorney performance. And that's something that is not only a constitutional obligation, but an obligation in Maine statute. And as Mr. Carroll just noted, the state still does not provide lawyers with the pay and the resources that they need in order to perform this work. Just as one example, the West Virginia Supreme Court recognized decades ago that the state of West Virginia was obligated to contribute to the overhead expenses of appointed counsel. This seems too obvious to even discuss. After all, none of the prosecutors in this state have to seek out their own office space or pay for their own rent or their utilities or their legal research tools or their support staff. The Sixth Amendment does not require equal resources on either side of the prosecution, but it is not meant to be a complete mismatch. And yet that is the system that Maine has tolerated. And the Sixth Amendment Center also found, as Mr. Carroll just discussed, that the rate of compensation for criminal defense attorneys in Maine is grossly inadequate. These are lawyers who are performing a public function. And if the state expects them to do a good job at it, to devote their careers to it, to getting better at it, to delivering those services on behalf of the state, it needs to pay them appropriately. After too many years of assurances that everything was fine, the Maine Commission on Indigent Legal Services finally acknowledged last year in its budget request to the chief executive that it needed to expand its programs in order to fulfill its legal and constitutional mission. And yet the chief executive so far has refused to provide funding for those new programs in her biennial budget proposal. This is disappointing, but not surprising. You know, in the scrum of the political arena, providing assistance of counsel for low-income people, it might not be surprising that it would be crowded out by more powerful interests and more powerful groups. But this is not, the right to counsel is not a political choice. It is a constitutional right. It is a state obligation. It's one of the very few affirmative rights in the Constitution. And it is now, I believe, to the legislature, who writes the budget and authorizes the budget, to make sure that that constitutional obligation is satisfied. As Chair Harnett alluded to in his opening comments, my organization is engaged in class action law reform litigation to address shortcomings in state indigent defense systems across the country. 2002 in Montana, and Washington State in 2004, New York and Michigan in 2007, Pennsylvania in 2012, Idaho in 2015, Nevada and Indiana in 2017, Missouri just last year. The results in most of these cases was that the state agreed to comprehensive settlement agreements, and they also agreed to substantial attorney fee payments to plaintiffs' counsel. For example, in New York, after 10 years of litigation, the state wrote a check for $5.5 million to the New York Civil Liberties Union for attorney fees and costs. The settlement agreements are publicly available, and the state of Maine does not need to spend years and dollars litigating the case here. It has all the information it needs to address the problems, and a number of people and organizations, including mine, who are here and willing to help. With that, I'm happy to answer any questions that you might have.
Thank you very much, Mr. Hayden. The first question I see is from Representative Evangelos.
Thank you, Mr. Chair. And nice to see you again, Zach. And very well stated, by the way.
Thank you.
I'm worried because the pandemic has caused money to be tight, and I'm I'm worried about whether or not we can get all the parties on board to commit to providing the resources that are necessary. But the more I study these deficiencies, I mean, honestly, it almost feels like a caste system to me. I mean, what do you think?
I think, consistent with what Mr. Carroll said, that the state's obligation to provide an adequate system, an adequate representation to assure the assistance of counsel to people who are accused of crimes who cannot afford their own attorney is driven by forces that are outside of those individuals' control. It's driven by the decision about how many people to arrest, how many people to prosecute, and those systems have not been shortchanged. I think Mr. Carroll made the point that we are maybe underpaying our prosecutors, but those are relatively well resourced compared to the defense system. We have put all of the burden of shaving off costs, of saving money on the people who have been accused of crimes who can't afford their own attorney. And that's just not fair.
Thank you for that. And last question, will you assure me that you and your organization will continue to hold our feet to the fire, and that you will use all options that are necessary, including the ones you've stated today, if necessary, to get our state in compliance with the Sixth Amendment?
I will assure you, this is an incredibly high priority for us here in Maine and nationally as an organization. And as Mr. Carroll alluded to, this is a fundamental constitutional right, one of the most important in the Bill of Rights. And we, as an organization, we're celebrating our 101st anniversary this year. We're not going away.
Thank you, Mr. Hyden.
Thank you, Representative Evangelos. I'm going to give a little bit of time to see if I see any blue hands pop up. Seeing none, I want to thank you very much, Mr. Hyden, for coming in front of us again today. And it's very good to see you. Look forward to working with you.
Thank you, Mr. Chair. Thank you all.
Our last presenter of the first portion of this morning's presentation is Rob Ruffner, who is an attorney who does indigent criminal defense work. And he has asked for the opportunity to talk a few minutes about other states' approaches and his suggestions for changes. Welcome, Mr. Ruffner. How are you today?
Thank you. I am well. Representative Harnett, members of the Judiciary Committee, thank you for the opportunity to speak to you today. Some of you know me. I am Rob Ruffner. I'm a resident of Yarmouth. I practice out of Portland, Maine. My practice is almost entirely indigent legal services, primarily or almost exclusively adult criminal defense. I started out as a prosecutor in the city of St. Louis. In 1999, I moved to Portland and practiced as an assistant DA for Stephanie Anderson for 2 years. And for over 20 years now, I've been doing indigent defense work in Maine. In 2007, in December, I formed the Maine Indigent Defense Center to talk about policy issues and try to work to reform Maine's, as Zach indicates, lack of a system. It was even more of a lack of a system back in 2007 when we were still under the judiciary. I participated in the Clifford Commission that led to the formation of the legislation that formed our current commission. I have served as a member of the Maine delegation to under the Obama administration, a summit on indigent legal services, and was there with the then executive director of the commission and the chair of the commission at the time. And I've had an opportunity to speak to a number of you over the years on this issue, and I appreciate that. I have lots of ideas and lots of thoughts, but I'm going to try to narrow things down since we are a third over the first hour of this presentation. I want to talk about the idea of a defender general or a chief public defender. And I think it relates to how to move this forward? Where do we go from here? And who's going to do the work to help get that done? In terms of the nuts and bolts work, or the weeds, as David Carroll said. Last week, I was speaking with Matthew Valerio, the Defender General of Vermont, and he described his job as representing the criminal justice system from the defense perspective, just like the Attorney General does from the prosecutorial or state perspective. That is a pretty good job description. It's easy to explain. You know, when the Attorney General comes to speak to you or tries to speak with the executive branch or the judicial branch, there's not a lot of introduction that needs to be done. What they're expected to do, the roles and priorities are clear, and Maine could be well served by such a position. We need that leadership, especially at this crucial time. Someone that can build the relationships and the coalitions to come up with the money to be put in a budget to move reform forward. In fact, the LePage administration proposed creating the Office of the Chief Public Defender I don't know how many, 4 or 5 years ago. I actually submitted public comment on that, which I shared with some of the committee, where I rewrote that portion of the bill. And there's a number of functions that either this committee could consider proposing to create that office in that position now, or to add the duties and responsibilities to the current legislation and description of the duties of the executive director for the commission. Some of those duties include to monitor and testify at the legislature when relevant legislation is being proposed, to come forth and be the voice of the defense perspective of the justice system. So when a bill changing the classification of a crime, either more severe or less severe, is up, that person can provide the committee and the legislature with the actual unintended consequences that may flow from it. To work to propose reform, not just within the legislature, but also policy-wise. Again, going back to Vermont, their efforts to work in criminal justice reform in the area of juvenile justice, in raising the age at which individuals are prosecuted in the adult criminal justice system, was a recognition of the realities of adolescent brain development. And they were the focal point for a diverse group of interests, including members of the legislature that wanted to move forward on that topic. We really don't have, and I know that a number of you have commented on that lack in the past, there hasn't really been a voice whose duty it was to come to the legislature and to report on the actual state of affairs if they weren't good, and to provide you with a position consistent with the defense and of parents and of individuals who might be involuntarily committed under the law. In addition, so there's a lot of sort of standards out there on this. They talk about responsibilities and duties, including to partner with law enforcement and the judicial branch to work to develop areas of criminal justice reform and to reduce crime in our neighborhoods. And I think that a lot of what we have seen in the opioid crisis would have been a real opportunity for the Office of the Defender General to participate and come up with some strategies to really not only improve the lives of Mainers who might otherwise fall deeper and deeper into substance abuse, but also to improve the rest of Maine that has suffered under the, what comes along with substance abuse, the crime that comes with it, the dependent children, families that are ripped apart. we have been missing that partner for progress in Maine. And so I think that to tackle these issues, I know that the Judiciary Committee has proposed adding 2 positions to the central office, but I think that honestly, that the commission staff is so overburdened that they could easily take up full-time positions of 8 individuals with all the things they're tasked with doing. And a position needs to either be created or carved out of their existing positions, where it is clear that their duty is to come up with a plan for the future and to find a way to implement that by working with the legislature, the executive, members of the public, and to build those coalitions rather than sticking with the status quo since 1971, apparently. We have not had anyone whose job has been to do that. And that's part of what we've been missing. If anyone has any questions, I know that we're almost a half an hour into the second hour here, so I'll pause. I have a lot more to say, but at this point, I think it's important you hear from the other parties as well.
Thank you, Mr. Ruffin. And there will be more opportunities to testify when bills are in front of the committee, but I appreciate your input today. Are there any questions for Mr. Ruffner? Seeing none, I want to thank all of our presenters for the first portion of our presentation today. Very good information shared with the entire committee. And I'm now going to turn to the Maine Commission on Indigent Legal Services. I've had the opportunity to attend a whole bunch of their meetings over the last couple of months and know that they are working hard with the new interim executive director and a re-energized body of commissioners working very diligently to try to make the situation that we have in front of us better and hopefully in line with our constitutional obligations. I am not sure what order they wanted to present in, so I am going to call on the commission chair, Josh Tardy, to outline how they would like to shape their presentation today. Mr. Tardy.
Thank you, Representative Harnett and distinguished committee members. I'm Joshua Tardy. I'm the chair of the Maine Commission on Indigent Legal Services. I'm pleased to report to you, Mr. Chair, that I think that we would actually have a quorum on the commission because I have 4 of my fellow commissioners here. I would also at this time like to introduce and turn it over to Justin Andrus, who is our executive director. And I recruited him and he came on. He's got 1 month under the hood, and I'm pleased to reintroduce him to you and your committee. And the commissioners on hold will be available to provide answers to questions. So if I may, Mr. Chair, I'd have you recognize Mr. Andrus.
Well, thank you, Mr. Tardy, and don't, even though you have a quorum, don't start a commission meeting on our time.
I'll try not to. Thanks.
Thank you. Mr. Andrus.
Thank you, Mr. Chair. Thank you, everyone, for the opportunity to address you. I'm not going to go back through all of the things that I've done because I know the committee has heard a lot of it. I do want to say for those listening, I have been in the role for not quite a month. I have been engaged in indigent defense since I was a student at the clinic at the law school for a year in 2001, and then in my private practice. And so this is a subject that is extraordinarily important to me. I know that at prior opportunities to testify before this committee, I've mentioned the things that we're doing. And so hopefully folks who are interested in the details of that can prompt me for that rather than have me lecture at you. But I'll start by saying that coming into this role, I identified and recognized the issues that have been raised in the reports, as well as additional issues that I experienced as an attorney practicing in this area. We have spent my first month here working to essentially triage and bring the organization into some form of operational compliance. I think we have largely accomplished that, and we've used the OPEGA report as an initial hit list of the things we could do to put some brakes on immediate problems. And now we are turning to addressing the underlying Sixth Amendment quality of service problems that Mr. Carroll and his organization have identified. I do want to say a few things in response to things I've heard previously. The Sixth Amendment report talks about 600 attorneys. That was over a 5-year period. The actual roster today is about 375 attorneys. And on the one hand, that may sound like less of a supervisory burden, 30,000 cases divided by a little more than half the number of attorneys we're talking about illustrates the significance of the oversight problem that lies there. I also want to recognize that we've gone from 3 to 4 people in the office staff in addition to our screeners. So we do have 4 at this time, but 4 is completely inadequate. I appreciate hearing from Mr. Carroll, it simply cannot be done. I appreciate hearing from Mr. Hayden that we can't do it with this amount of staff. We can't. I know that this committee recognizes that, and I appreciate its support a week or 2 ago in voting to authorize us to have additional staff people. But I want to continue to reiterate that it is impossible for us to do all of the things that we've been charged with doing with the staff that we have now. I also want to recognize that it's about to get much more complicated. These numbers are approximate, so bear with me, but in the beginning of February 2020, there were approximately 18,000 cases pending in the Unified Criminal Docket at pretrial or pre-conviction status. There are approximately 27,700 pending today. And so all of the problems that we've identified in terms of quality of services, caseloads, proper numbers of attorneys, adequate oversight are going to be multiplied by a significant amount when all of those cases come home for trial and resolution as the courts open back up. And so the problems that we see with funding today are real, but they're significantly understated. And we simply cannot do this without additional help. I also want to reiterate what both Mr. Carroll and Mr. Hayden said about the funding for one side of the issue and not the other. The significance of that to our ability to provide constitutionally adequate representation cannot be overstated. And I'm going to spare you the picture of a parking lot full of unused state police cruisers, but it frustrates me to no end that that funding is not available for us at some level. I also want to bookmark for Mr. Carroll if he has an opportunity to address this, and forgive me, committee, for asking a question of him. But when we were talking about the issue of whether a charge would result in incarceration, one thing that I think we need to address is the reality that prosecutors are currently able to determine whether an indigent defendant is entitled to counsel by marking a case no risk of jail. And so since a judge ultimately has the ability to turn down any plea bargain that does not involve jail and require that jail be imposed, it seems problematic to me. And I think that should be part of our dialogue in terms of what we're looking at for controls on the state's ability to impact defendants, particularly without adequate counsel, or any counsel in some instances. So I think I'll stop preaching to you and open for questions. I'd be delighted to share the very specific things that we've been doing. We've been through the OPEGA report. We've hit most of the elements of the OPEGA report itself. We have a plan for moving forward. And I guess I'll just stay in broad terms. There's this underlying question of public defender office versus retained or contracted private counsel. In the immediate term, my strategy is to revise the private contract side of things because I can do that within the existing framework, to promulgate a contract that will contain much more extensive terms about oversight, about training, competence, review, financial integrity, audits, recoupment, and to promulgate that for the turn of the fiscal year so that the, attorneys are signing into that by continuing to go forward with us. That does give me a several month time frame. It's not as immediate as I would like, but I am learning that things move more slowly in this realm than they do when I have my own office and I'm the only guy there. So that's the overarching strategy is we've triaged. I think we've stopped the bleeding. We're into compliance. We have begun, I can't get into detail, of course, in this forum, but begun a process of looking at both quality of service problems as we become aware of them and billing issues as we become aware of them. And now we're going to pivot to rebuilding a structure rather than continuing to patch the existing structure. And in doing that, forming my initial thoughts, I've relied pretty heavily on documents from the National Legal Defense Association and also from Massachusetts, where there was a pretty extensive document set to use as a reference point, issue spotting and ideas. Mr. Chair, I'll turn it back to questions at that point.
Thank you very much, Mr. Anders. I appreciate that presentation. And we often hear the expression when someone takes a new position that they hit the ground running. I think that applies to you across the board. I've been remarkably impressed with the work that you have done, and I appreciate it. Thank you for that. And I see one question, or at least one questioner, Representative Moriarty.
Thank you, Mr. Chair. Justin, I couldn't quite write fast enough to keep up with some of what I was hearing, but a moment ago, I think you mentioned that prosecutors can make a notation that a case is not flagged for incarceration. Can you amplify on that a little bit for me?
Yes. I don't know in each prosecutorial office how this decision is made. I only know the practical effect on the defense side. But a prosecutor has the ability to mark certain cases as no risk of jail. Now, the prosecutor in that case is binding its office to not ask for jail in that case. But in that instance, that defendant is then not eligible in most instances for counsel. That is hugely problematic for a variety of reasons. First off, there are all sorts of collateral consequences that adhere to all criminal convictions. Then there are specific collateral consequences that adhere to specific individuals for any conviction that that person may get, including without limitation, immigration consequences. And then there's the underlying problem of if a judge were to reject a plea and say, no, this person needs to be jailed, the case could get recycled, counsel could get appointed, but the defendant will then be quite far into the process. There may be spoliation or preservation of evidence issues. The person may have made statements that could conceivably be used against them. It's very problematic. In my view, the prosecutor should not have that role in determining which defendants get counsel.
Well, so if it is the mere possibility of incarceration that triggers the right to court-appointed counsel, you're saying that a prosecutor should not have the authority to commit that incarceration will not be sought as a penalty?
I think more specifically, I'm saying a prosecutor does not have that authority because ultimately a judge has to approve a plea.
Yes, I understand.
So not only should a prosecutor not have it, I do agree with that proposition, but they in fact don't have it. And yet historically that's been applied that way.
So what purpose is accomplished by marking a case as not suitable or recommended for jail?
I'm not going to speculate on what the underlying goal of the prosecutor may be. I can imagine reasons I might do that in certain cases if I were a prosecutor, but I have not had the benefit of knowing from a specific prosecutor why they might make that choice. And remember, they can not mark at no risk of jail and still not ask for jail. And so it really has a gatekeeping function that's that needs to be gone. It needs to be the most basic criminal charge in Maine anywhere can carry a risk of incarceration.
Yeah,
that should be the trigger for appointment.
Okay, so the bottom line is that no matter what the prosecutor writes on the summons or whatever, it doesn't take it out of the scope of the Sixth Amendment.
It doesn't. It takes it out of the scope of present practice. At the risk of getting myself in trouble speaking just before lunch, if I'm presented with that, I'm going to appoint counsel because the Sixth Amendment requires it. But we need to fix that at a statutory level also as we deal with the unrepresented defendant problem.
Does that take care of your questions, Representative?
It does, yes. Yeah, I'm all done.
Thank you very much. I have two people in the queue. The next is Representative Evangelos, followed by Representative Babich. Representative Evangelos.
Thank you, Mr. Chair. Hi, Mr. Andrus.
Morning.
I read the OPEGA report and I just want to make sure I give a clear understanding regarding the overbilling issues that the conclusion was that much of the overbilling issues may have been overstated and that some of the time cards that were presented by specific lawyers actually involved other attorneys within the firm, and it kind of skewed the results. And I just wanted to, I know that Senator Carpenter asked some clarifying questions last session about that. Am I correct in my understanding on that?
I think so. What I think is fair to say is what OPEGA said, which is that in looking at that data set and looking at the conclusions reached by each report, it's difficult to assess with numerical specificity how many people may have overbilled or to what extent. It is not, however, the same thing as saying that the issues identified are not genuine and problematic. And so we're going into addressing things in a number of ways. And my role at the moment is, both operational triage, planning, short-term planning, long-term. And so things sort of nest in funny ways. So I'll try and make this make sense. But one of the things we're doing to ensure that we have useful information and accountability going forward is promulgating a set of billing standards. I thought I was ready to do it until I gave it to a commission member who said to me, you have to know what you meant in order to understand what this says. So I need to do some redrafting there to bring some clarity to it. But that the billing is going to specify some very detailed things, including that all billing must be in the specific name of the person who did the work. I don't have a practical way in the existing system to make that be under oath, but I can make it an attorney certification, which is at least somewhat useful. And a number of other very detailed things about how time is to be not aggregated, what's to be billed for and how much. The short version on that is the actual time spent, and to make it clear that no staff time may be billed. Because one of the issues identified in the reports was the idea that staff was being billed as attorney time, and the rules prohibit that. And we're going to need to address going forward that data is clear that that's not what's happening. Retrospectively, I don't want to speak with a scientific accuracy because I'm not sure it's possible to do that from the data set. I will be, I hope, speaking with Matt Kruk. We've emailed about setting this up from OPEGA to talk about what's actually in the data and how it can be used, what purpose it can be used for, and identifying what issues actually exist.
And just to follow up, and I'm not going to get into any specifics at all. However, I am familiar with a particular case where an attorney worked for nearly 2 years to free a man from prison, and was actually successful after 27 years of serving the prison sentence. That man was freed, and I know that cost a lot of money to do, but when the Attorney General's office gave their report to us last year, they said that private legal counsel earns up to $300 an hour. This particular case involved an excruciating amount of overtime, unprecedented in its results. So I'm a little bit concerned about the optics that an attorney who is successful against the state, finally, it wasn't quite an exoneration the way it worked out in the end, but I am a little concerned around the optics that an attorney who took on the state, maybe becoming under scrutiny for the success that they had. So I'm just going to leave it at that. But I just want you to be sensitive to that. That was a very, very long, arduous, difficult case.
It was a spectacularly successful case from our perspective. And I will not address any issues of any person in answering that, but I recognize that our attorneys need to be lauded and congratulated for the good work that they do.
Thank you for that.
I've been one of those attorneys.
Thank you, Representative Angelos. I next have up Representative Babbage, and I see Representative Moriarty has raised his hand again. Representative Babbage.
Thank you very much, Mr. Chairman. Mr. Andros, good to see you again, and thank you for taking on this position. Representative Moriarty did ask a question that I just needed to follow up on for my own clarification. I taught in class many years about the right to counsel if there was a loss of liberty at stake. But when you talk about no risk of jail time being designated by a prosecutor, is that accompanied by a corresponding reduction in charge?
No. And it could be, usually see it on Class D or E charges exclusively. And it could be on an E charge where there is no available reduction, at least in the criminal system. It could be on a D charge, but no, it is not typically accompanied by a reduction in charge.
Is it common or for indigent defense to be provided for cases in which jail time is not a factor?
I can't answer that. I don't have statistics to answer that question for you. But I would respond by saying, if it's a criminal charge, a risk of jail is a factor. The prosecutor just doesn't have the authority to constrain the court. Now, practically speaking, courts normally don't go down that road of trying to impose jail and recycling it. But it's still extraordinarily problematic because it allows a prosecutor, for whatever reason, perhaps good prosecutorial reasons, but not defense reasons, to choose to ensure that a defendant doesn't have counsel, at least from their perspective. And that's highly problematic. Anecdotally, I can tell you that I frequently heard or spoke to clients, existing clients who had other cases, or potential clients when I was in private practice. They came to me with charges, and I said, if I'm appointed, I'll accept professional responsibility for that case. And it was not at all uncommon for then to be no risk of jail. I would frequently advise them on a limited basis on pro bono, help them in some way, but it happens enough for it to be a non-trivial issue. And I think it goes right in with the piece about talking to unrepresented defendants at the outset of the lawyer of the day process.
Yeah, thank you for the clarification. Thank you.
Thank you, Representative Babbage. Representative Moriarty.
Thank you, Mr. Chair. I have a question for Mr. Tardy, but I don't know who's on deck and what the agenda is from this point on. Do we have time, or?
We're about to find that out. So if you don't have a question for Mr. Andrews, I assure you, you'll get a chance to ask Chair Tardy a question.
All right, I'll hold off until the appropriate time.
Mr. Andrus, I see no other questions for you. Did you want to have us hear from any, you have one of your employees or colleagues on the call?
Deputy Director Masiag is here, and I appreciate that. But I think unless she wants to pipe up, we've covered it. She's been a really useful resource because she has the institutional knowledge. And sometimes in these sorts of events, I need her to feed me an answer when I don't have a data point.
Thank you. And thank you for your service, Ms. Masiak. Chair Tardy, I'm first going to ask, do you have commissioners who want to speak, or are they simply available for questions if committee members have questions?
I'm actually not sure. I would ask if a commissioner would like to address the Judiciary Committee to raise the hand function on the Zoom application, and we'll go from there. But I'm certainly in a position to answer questions at this time, Mr. Chair.
Okay, and I see one hand up from a commissioner who I will call on, but before I forget, which I often do, I'd like to have Representative Moriarty ask the question that he had for you as chair.
Sure.
Okay, thanks very much. Good morning, Josh. Good to see you.
Nice to see you.
You've been at this for a while, and I'll bet you've been asked this question a number of times. It's just that I haven't found the answer either in the 6AC report or in the Commission's November 2020 final report. Briefly, what would it cost Maine to establish a public defender system?
Thank you. So what we did submit, Representative Moriarty, is the Kennebec defender that was county specific and a statewide appellate, and that's part of our budget proposal. And Ellie Maciag I'll ask her to either text me or to weigh in. Those each had specific items. They're very, I can tell you that our biennial budget presentation went from roughly $38 million per biennium to $70 million in the biennium. That's costing out in a very non-OFPR way the cost of a defender office in Kennebec County, and I'm not prepared to give you sort of the under the hood of that, and I apologize, but I can get that information to you, and I think Ellie might be able to access that readily.
I can look it up and get back to you in just a minute.
Okay, thank you, Ellie.
Does that take care of your questions, Representative? Okay, I see two commissioners have asked to make comments. The first was Commissioner Robert Cummings, and the second will be Commissioner Mike Carey, followed by Commissioner Ron Schneider. So I will start with Mr. Cummings. Commissioner Cummings, welcome.
Thank you, distinguished members of the legislature. And the name is Cummins, actually, no G, but that's the fault of my computer, I think.
Okay. I blame my computer all the time, but go ahead, Mr. Cummins. You're muted, sir.
I would ask the committee to reflect a bit on the indictment. Let's put it that way. The indictment presented by Mr. Carroll. If the ACLU under Mr. Hyden's direction were to initiate a lawsuit against the state of Maine or other relevant parties, I think putting it in indictment terms, it's pretty clear that the state would have to plead guilty. And that's been the circumstance for, based on my investigation of the history of indigent representation in Maine, that's been the circumstance for decades. It seems to me it's time to rectify this situation, and I believe that MCILS in our proposals for funding have provided a vehicle for beginning that repair, if you will, or replacement of a defective system. I think, if I recall correctly, and Ellie will correct this, I think our projected budget for the Kennebec project was something under $2 million. And she'll rectify that. But here's what I'd ask us to reflect on, all of us. We have been aware of and have known that the system of representing indigents in the state of Maine has been deficient for years. Keep in mind that that has undoubtedly led to the conviction of more than one indigent individual. Statistics would back that up. So how many indigent folks are sitting in jail today because of the lack of a responsible governmental action to protect their interest, mandated by the Constitution? If we reflect on those individuals who have been disserved, who have been wrongfully prosecuted, and are spending time in prison, that's such a disturbing circumstance that no competent lawyer should be willing to accept that. or any citizen of the state should be willing to accept that. I don't want to prolong this. I have been involved in the representation of indigents, both in state and federal court, in a system that had a public defender office, a federal defender office later, for about 60 years. I've handled post-conviction cases where individuals were not adequately represented by counsel. We're talking about lives here. We're talking about human beings being disserved by its government. Reference was made to tyranny. For those folks, they have suffered that tyranny. You, Mr. Chairman, made the point that we're addressing a sacred obligation. A sacred obligation. And as much as folks want to and should investigate the issues of financial responsibility and accountability, I draw a bit of an analogy to a truck. If MCIL is the truck that's supposed to drive constitutional compliance with the Sixth Amendment, we've spent years and many dollars looking under the hood and inspecting the spark plugs when in fact we need an engine and we need a full tank of gas. And I hope that that can be accomplished. I think the Kennebec project will prove the credibility of a defender system consistent with the Sixth Amendment. I think that should be a priority. And I just want to make one final point. Justin Andrus, and I commend our chair and my colleagues for selecting him to serve on this interim basis. But I think it's pragmatically extremely important to understand that Mr. Andrus is currently serving on an interim basis. And if you were to ask him, well, would you take the job full time? I think the answer is going to be no. And you ask yourself, well, who else would want to step into this position if you're taking over a job to supervise a system that isn't functioning correctly and has not functioned correctly, despite the good faith efforts of a lot of folks, including the commissioners of the MCILS. So I made and this is just a personal pitch, but I put your money where your mouth is. I said to Justin, listen, if all the conditions of creating a proper system could be satisfied, would you hang in as executive director? And if you would, and if we had the funding for Kennebec, I would, without any compensation whatsoever, completely pro bono, I would take the job of public defender of Kennebec County and create an office and prove its credibility. Now I'm about to be 88. So as I said to someone, I'm going to hang in and until I see this accomplished. And I just hope that we can rectify this circumstance. We have the vehicle for doing it. We need the funding. You've heard all of the reasons why it can't persist as it has. Frankly, if the public heard the presentation of Mr. Carroll this morning, they would believe that Maine's system for dealing with indigent representation is a disgrace. And of course, there's lots of other issues in the criminal justice system that have to be addressed, but hopefully we can get this fixed. It has to be fixed. Thanks.
Thank you, Commissioner Cummins. And I know that I said we would next hear from Commissioner Carey. and then Commissioner Schneider, but I did see a hand up from Representative Evangelos, who I assume has a question for Commissioner Cummins. You're muted, Jeffrey. Representative Evangelos.
Thank you, Mr. Chair. You're correct. I was muted. Thank you very much, Mr. Cummins. I remember during your confirmation hearing with the Judiciary Committee, I had done some extensive research about you. And I don't think probably most people in the state and probably many people on this call today are aware of your history. I did read the Cook County report from 1971 to 75 that you submitted to us on how you changed and addressed the indigent legal representation system in Illinois. But you have also had some successful exonerations freeing innocent men from prison, have you not? He's muted, Tom.
Yes, I have.
So my question is, it's like a conscience crying out, I've become convinced that we have a few innocent men in Maine's prisons, and we don't have a good avenue to redress that grievance. So are you of the opinion that we most likely have some innocent individuals in our prisons here in Maine?
Well, there's no question about that. I mean, you just have to look at the history of criminal prosecution in the United States. Yes, and more tellingly, there are people that are sitting in county jails right now who haven't had an opportunity to go to trial, who are innocent, who have not committed the crime, who weren't in the bank, who weren't in the home, who didn't steal the car, who didn't engage in the holdup. They're sitting in the county jail, and they could likely be provided with one of those ineffective, inexperienced lawyers who does not have the skill, experience, or know-how to adequately defend them. So what's their future? What's the future of the innocent person currently waiting trial in this state if it's going to be the luck of the draw whether they or not they get an experienced, competent counsel who will provide the quality of representation that MCILS is mandated to supply? It's a scary proposition, but it's worse for the individual.
Thank you very much for that. You're a terrific resource for us, and nothing much worse can happen to a human being or a family than to have the wrong person, behind bars. So, thank you for everything you're doing for us, and I hope everyone on the call heard your generous offer.
Thank you, Representative Evangelos. Commissioner Cummins, I see no additional questions. I truly appreciate your time today and the times I've heard you speak at commission meetings, and I know that we did a fine job in appointing you in the last legislative session. So thank you very much for your service.
Thanks, sir. Actually, it's been my great privilege.
Commissioner Michael Carey is up next.
Thank you, Mr. Chair. I'm struggling a little bit with bandwidth issues, so forgive me if I'm coming in and out. Are you able to hear?
We are. If it doesn't bother you, sometimes if you shut your video off, not that we don't like seeing your face, it can increase the sound quality.
Well, let's hope for that. I wanted to speak just briefly on the issue of ensuring quality, which is the language in the statute is that the state ensure quality. In addition to being a commissioner, or as a commissioner, I serve as I chair the financial responsibility subcommittee. And I see the two reports as interlocking, as describing an interlocking whole. The OPEGA report, as Justin indicated, provides a very, very useful and effective tool to identify specific issues and provides actionable recommendations to address those, and we have. That cannot be separated from quality, and I want to highlight that I agree with both reports to the extent that it described ineffective and inappropriate stewardship of public funds. That, in my opinion, must change, and I think it has changed. And I will continue to be part of ensuring a proper oversight of public funds, but that's not sufficient. And as the two reports have indicated, I guess, and I'll leave. And it's not just a qualitative issue, which obviously is related to funding, but there's actually just a really basic measure. And as one requirement that Zach mentioned, and I want to kind of go back to that, the statute requires that the commission institute rules on how the state will evaluate council. In about 12 years since the commission has been put into place, that hasn't been done. And with existing resources, frankly, I don't know how it could be done. But the very fact of the matter is that the legislature passed a statute that required the commission to pass these rules, and it has not done that. That, to me, speaks to quality. It affects quality. It speaks to the commission not meeting its statutory mandate. And I hope with your oversight and that of the rest of the legislature and the chief executive, that we're able to get the funding that we need to be able to meet statute and to meet the 6. Thank you very much.
Thank you very much, Commissioner Carey, and thank you very much for your service on the commission itself. Are there any questions from committee members for Commissioner Carey? Seeing none, I will move on to Commissioner Ron Schneider. Welcome, Commissioner Schneider.
Thank you very much, Representative Harnett, and thank you very much for this meeting. I just wanted to briefly say a couple of things. When I listened to David Carroll talk about the state of our defense system, I can't help but just look back at the history and say, it has always been this way. It's always been this kind of problem. We are engaging in further debate about something that I feel is just obvious. It's been debated for a while now. You go back and report after report after report. The only reason we didn't have a public defender system put in place was because it was a bargain to do it the way we're doing it, or because the lawyers who were in the system didn't want it to change. Not because it wasn't the right thing to do. And I think one of the things that the legislature needs to do really is to move forward, to do what's right and not worry about the public. I don't have the same faith in the public that Commissioner Cummins has. I think this is a very unpopular cause. And we need to move forward as a state to do what's right, not worry about the lawyers who make a living off this current system, because I'm sorry to say, this system isn't put in place for the lawyers. This is for the people who need quality representation. When I hear David Carroll talk about our criteria for appointment being too lenient, I think back to sitting in the Judiciary Committee as the first chair between 2009 and 2012, and in your committee room with a room full, packed full, standing room only, of people opposing our specialty panels, including the Maine State Bar Association. And we put in the best rules we could to create specialty panels in spite of that opposition. And we find that over the years, those rules have not been put in place. Commissioner Carey talks about, as he just mentioned, we didn't have a way to evaluate. It's true we didn't have specific rules for evaluation, but we've had standards of practice since the beginning. That was one of the first things we put in place. And then now, you know, when I came back onto the commission after not being on after 2012, coming back on, hearing people say, we have standards. I didn't know there were practice standards. We do have practice standards that were established using a compendium of standards from around the country. We didn't just make them up out of whole cloth. The fact is that there's just no way to take a look to oversee the quality of representation. People like to look at the bill and say, oh, we can tell that, oh, that person did a good job. There's no way you can tell that a person did a good job because of the bill. You just can't do it. And we still are getting a bargain. The average cost of a voucher is abysmally low. It's actually a problem. You talk to Zach Hayden, he'll tell you it's a problem. It's so low. It indicates a lack of work. We hear about a very small percentage of cases where a motion to suppress is filed. I've not done a tremendous amount of criminal defense work, but I've never not filed a motion to suppress. There's always something to argue about. We hear about people not visiting the jail. I've heard from people saying, go look at the visitor logs and you won't see many lawyers on those visitor logs. Again, I've never not gone to visit a client who's in jail. I've not had that many. I'm not a full-time criminal defense attorney, but still, we have a significant problem with overseeing the quality of criminal defense. And I just want to give you that kind of historical reference. We are talking about something that has been talked about now for going on 40 years. And it's time that we actually do something. And I think you're going to have to leave behind the people who oppose it, because they're opposing it for their own personal gain, not because it's not right. We are not that special in Maine. We simply are not that special. We are the only ones who don't have a public defender system. Why do we think Maine's a great place to live? We are special in many ways, but not in that way. We have to move forward and we have to leave the opposition behind. Thank you. I appreciate it.
Thank you very much, Commissioner Schneider, and thank you very much for your longstanding commitment and dedication to this work. It does not go unnoticed. Are there any questions from committee members for Commissioner Schneider? Seeing none, I will ask, are there any questions from committee members for anybody who has presented today that is still available at this meeting? Representative Libby.
Thank you, Mr. Chair. I think that this is a question for Mr. Tardy, but I'm happy to be corrected if that is not the appropriate person. So thank you for being here today. My question is in the Sixth Amendment report, it references a Cumberland County trial level public defender office. What was the rationale behind choosing Kennebec County?
So we had a subcommittee, good afternoon, I guess now, Representative. We had a subcommittee that looked at the various places that we could use sort of a startup of this. I don't want to use pilot because by design it would have been what we would hope been a permanent installation. Kennebec was going to be less expensive, wasn't going to be quite as big of a first project, and it was closer to the Capitol and to the Maine Commission headquarters. I know that Commissioners Schneider and Cummins were on the subcommittee that has looked at the public defender model for the state, and they may be able to speak more precisely to that. But it was a lot of it has to do with the dollars and cents of making a credible budget proposal.
So this is seen as a stepping stone, would you say?
Yes, if we we think that moving to a public defender model makes sense, as Commissioner Schneider, Commissioner Cummins have indicated. And if we could sort of get a Kennebec County program up and running, and it would be able to prove its merit, and then we could expand as legislator and policymakers make that decision going forward.
Thank you very much.
Representative Libby, thank you, Commissioner Chair Tardy, but I believe that Commissioner Cummings might have some information to answer your question as well.
Perfect, thank you.
Commissioner Cummings?
Let me just back up what Josh explained. He's completely correct. But one of the other reasons that we picked Kennebec was that I went up there and sat with Judge Michaela Murphy and with Megan Mahoney, the prosecutor. They opened the door. They invited this effort. It's a workable proposal, and it represents an opportunity to prove to the legislature, to the executive and judicial branches, that a public defender system can really work. And as Josh correctly pointed out, this would be the stepping stone for establishing related offices throughout the state in a form acceptable and unique to Maine. So that was part of the motivation as well, at least part of my motivation when I was able to confer with my fellow subcommittee members chaired by Mr. Schneider, who has demonstrated, as you noted, Mr. Chairman, a great deal of his time to this effort.
Thank you, Commissioner. Does that
Thank
answer
you.
your question, Representative?
Yes, it does. Thank you, Mr. Cummins, and thank you, Mr. Chair.
Thank you. Are there any other questions from committee members? I'm actually happy. Oh, I was going to say no blue hands. I should have closed it sooner. Representative Evangelos.
Thank you, Mr. Chair. Just a thought that the chair can advise us on, or Josh Tardy can advise us on, but we are going to be appearing in front of appropriations. Is that correct?
That is correct.
So I just, we all have to come together and make the strong case. This can't go on. And it isn't just a matter of funding those two positions for the rest of the fiscal year. We have to set the ship on the correct course. Mr. Hayden has eloquently laid out the risks if we don't. And I hope the committee can come together and make the demands that are necessary on the Appropriations Committee and get our message across that this has to be a priority. Part of what Mr. Schneider was referring to reminded me of my question about, we do have a caste system and we need to rectify it. And I just hope that the committee will work together and make the Appropriations Committee and to the extent that we can, the Chief Executive Office, the seriousness of this situation. I can't understate the case that Mr. Carroll made today. And so I just wanted to make sure that our committee can have a discussion before we go into appropriations so that we have a collective strategy. Thank you, Mr. Chair.
Thank you, Representative Evangelos. And as you know, and as the members of the committee know, the committee was unanimous in its recommendation regarding the supplemental budget about the need for increased funding for the commission. And that was a vote from all sides of the aisles that we have on our committee. So I would hope we continue that moving forward. If there are no other questions, and I will keep staring for the blue hand, I do know there was an outstanding question that Ms. Masiak was going to look into for Representative Moriarty. Without putting you on the spot, I'm putting you on the spot to see if you found an answer.
and I can resolve it. Ellie has given me the info. It's the Kennebec project, Mr. Chair and Representative Moriarty, is over $4 million in the biennium. It's approximately $2,100,000 a year.
Thank you. Does that answer your question, Representative Moriarty?
Actually, my question was, what would a statewide public defender system cost?
Ms. Maciag?
Oh, we did not budget out other than the Kennebec and the appellate statewide. We only did those two offices, so we don't have the numbers on a statewide public defender.
Okay, I'll just leave with an observation very quickly. We apparently have 49 other jurisdictions with defender systems, 49 other models to which we can look for guidance and so forth. We don't have to reinvent the wheel. And it just sounds to me that inevitably we may have to go in that direction.
Thank you, Representative Moriarty. And I did see Commissioner Schneider put his hand up. Did you want to address this issue?
I believe that the issue of, understanding that we do more, we have to actually look at it in a larger amount because we do more than just criminal defense. But I believe that currently, and Rob Ruffner may have an answer for this too, but if you look at New Hampshire with a similar population, similar case numbers, they're about 18 or 19 million for their entire state. And they do provide public defense service, defender services in every county, even where they don't have an office necessarily, they go into those counties. And then they also do have some contract work, but they provide 85% coverage for the cases, and the other 15% are conflict cases. So I think it's in the neighborhood of 18 to 19 million total.
Thank you, Commissioner Schneider. Mr. Ruffner, briefly, do you have anything to add to that or confirm that?
I would say that it's important to remember that New Hampshire does not cover everything that the commission covers. And I do not, because I didn't think to pull it up and have in front of me what their current budget is, but they have been in existence for a long time. They are viewed in our neighbors in New Hampshire as a fiscally sound and policy from a policy perspective, as well as a sound governmental, good government choice, and are also recognized as doing very good work. They do not have a problem recruiting new attorneys to that office. They are sought after. So, but I would point out that we shouldn't be held back by the anchor of how we've underfunded our system, because we will always, compared to doing what we're supposed to be doing, it'll appear expensive just if we look at dollar and cents. But if we look at the cost to not just the clients, but the drag on our economy, the amount of money we spend on prisons, et cetera, we are being very much pound foolish in Maine by keeping the system we have now with its current level of funding.
Thank you, Mr. Ruffner. I'm going to give the last word other than me closing the meeting. Briefly, as we have another lengthy meeting about to begin and I need to give the committee a break, but Commissioner Cummins, last word on this issue?
Well, I was just going to say, we have to be careful when we start focusing on finances. What is it worth to our state to be able to say we provide quality representation to those indigents who need our services, and we, the state of Maine, fully comply with the Sixth Amendment, and we do a great job at doing so. Yeah, it's going to cost some money, but it's worth every cent.
Thank you very much. Powerful words to close on. I really want to thank everybody for what I thought was just a fabulous presentation with great questions. I particularly want to thank David Carroll, Zach Hyden, Rob Ruffner for their presentations, and also Justin Andrus, Ellie Macieg, Josh Tardy, and all of the commissioners for the Maine Commission on Indigent Legal Services. You do amazing work, and you've given us a lot to think about. And as I said, we are talking about a constitutional obligation, and we're talking about human lives. I can think of nothing else that could be more important. So with that, I'm going to close this morning's meeting and let committee members know that you have 34 minutes to relax, stretch, do whatever you need to do, and we will see you again at 1 o'clock. Thank you very much.
Hi, Sam. Just checking in. We don't quite have a quorum yet. We'll just wait another moment for some additional committee members to return. All right, I'm seeing significant number of committee members have returned. Good afternoon. I'm sorry to have missed this morning's presentation. I was introducing a bill before another committee. Let's see, and I don't know, Representative Hagan, were you in attendance this morning?
Hi there. No, I was not. I was at a Leeds meeting in Augusta at the Sportsmen's Alliance of Maine. I literally just walked through the door, so glad to be here.
Yeah, I think you and I are in the same boat because
Yeah.
I feel like I'm just fresh into the committee as well. So why don't you go ahead and introduce yourself and then I'll introduce myself.
All right. Thank you very much, Madam Chair. I am David Hagan. I represent House District 101, Hamden and Newburgh.
And I'm Senator Ann Carney. I represent Senate District 29, which is South Portland, Cape Elizabeth, and some of Scarborough. And I believe that committee members introduced themselves this morning, but perhaps we should do that again. I see Representative Harnett nodding, and I think that makes a lot of sense. So while you and I jumped the boat, Representative Hagan, let's see. Let me grab my list here. I literally just am transitioning from one thing to another. I'm just going to call on committee members looking at the screen. Representative Babbage, why don't you start off?
Thank you, Madam Chair. My name is Chris Babbage. I represent House District 8, which is part of Kennebunk.
Thank you, Representative Moriarty.
Thank you, Madam Chair. Steve Moriarty from District 45, which is Cumberland and part of Gray.
Representative Libby.
Thank you, Madam Chair. I'm Laurel Libby. I live in Auburn and I represent District 64, which is part of Auburn and all of Minot.
Representative Sheehan.
Thanks, Madam Chair, and good afternoon, everyone. I'm Erin Sheehan and I represent House District 12, that is downtown Biddeford.
Representative Harnett. Tom, you're muted.
Thank you. My name is Tom Harnett. I represent House District 83, which is the town of Farmingdale and the city of Gardner, and that was very easy for me to say. Thank you.
Representative Reckitt.
Representative Reckitt, representing District 31 in South Portland. Sorry for the slight noise. I'm voting in another committee on the other Zoom in the other half of my room.
Well done. Representative Evangelos.
Madam Chair, hello, everybody. Good to see you again. Jeffrey Evangelos, House District 91, and I live in Friendship. Thank you.
And Representative Newell.
Thank you, Madam Chair. Good afternoon, everyone. I am Rena Newell, Passamaquoddy Tribal Representative, and I would just like to welcome Ambassador Dana, as well as our tribal attorneys, Corey Albright, Allison Binney. That's who I'm seeing, as well as I believe it might be Maine Tribal State Commission is here. Mr. Oh, I lost him on the screen. Paul Thibault. Thank you.
That's a good reminder. I'll ask everybody to introduce themselves in just a moment. And then I think Representative Poirier, you were next.
Thank you, Madam Chair. Jennifer Poirier, and I represent House District 107, which is all of Skowhegan and a small part of Madison.
Thank you. And I'd like to introduce our analyst, Sam Seneff, who is going to help us with today's presentation, and also our committee clerk, Susan Panett, who is on in our electronic meeting with us. I think, and also our analyst, Peggy Reinsch, is here as well. And I think I've covered committee members, our clerk and analyst. And at this point, I'm going to commence our afternoon presentations, which involve the tribal state relations, tribal sovereignty, and federal Indian law. And I will call on other members to, other attendees to introduce themselves and to let us know a little bit what organization you are with. So I'm going to start with Ambassador Dana. Could you please go ahead? And my dog is barking, excuse me.
If my dog hears that dog, she'll probably bark too, just a warning. Good afternoon, everyone. My name is Molly and Dana. I serve as the tribal ambassador for the Penobscot Nation. It's really great to see you all today.
Thank you. Ms. Binney?
Hi, good afternoon. My name is Allison Binney, and I represent the Penobscot Nation, both in a legal capacity, but also as their federal lobbyist.
Thank you. Kimberly Pat Warden?
Hi, good afternoon. I'm Kimberly Pat Warden. I'm an Assistant Attorney General.
Thank you. I see Kirk K. Francis too, and I'm sorry, I'm not remembering your entire name. My apologies.
Good afternoon, everyone. I'm sorry I'm having camera difficulties, but it's good to see everyone. I'm looking forward to listening in. It's Kirk Francis from Penobscot Nation.
Thank you very much. Let's see, Chris Taub.
Good afternoon. I'm Chris Taub, Chief Deputy Attorney General at the Maine Attorney General's Office.
Thank you. Corey Albright.
Good morning. It's nice to see everyone from the committee, the old faces and the new faces. It's good to be back before you. I represent the Holton Band of Maliseet Indians.
Welcome. Chief Sabatis.
Good afternoon, Chief Sabatis from the Holton Band of Maliseet Indians, and it's good to see everybody, and I'm looking forward to listening in today.
Thank you. And Paul Thibault.
Good afternoon, Paul Thibault, Managing Director of the Maine Indian Tribal State Commission.
And then Tom Abello.
Good afternoon. I'm Tom Abello. I'm the Legislative Director for Governor Mills.
Thank you. Who have I missed, if anyone? Not seeing any raised hands. So at this point, Sam, I'm not sure if it's appropriate to turn things over to you, but I feel like that might be a good next step. Could you to kick us off here? Thank you.
Absolutely. My name is. When I'm on these meetings, I don't know. Okay. My name is Sam Seneth, and I am a legislative analyst for judiciary. And what we are doing today is, I think, a little bit atypical in that we're going to be doing some sort of pre-planning for the tribal sovereignty bills that the committee will be seeing later this session. Now, we don't have those bills in front of us yet, but we have quite a bit of legislative history to go over. So I want to do that. I would like to help orient the committee to how we got where we are today in this process, and also start the process of going over to some extent some of the background law that underpins this work, because it is a little different than a lot of the things this committee sees. The body of Indian law is very much it's complicated, and it's very much its own thing, and it can take some time to sort of get used to. And I have perhaps the unenviable but also enviable job of presenting this information when there are people in the virtual room who know a lot more about this than I do. So it's bad because they'll know that I make a mistake, but it's good because they can correct me when I make a mistake. So if it's okay with the chairs, I would just I would like to just say, if I do make a mistake, please correct me on video, so we can write that.
Sam, would you like people to raise their physical hand, use the raise hand function, or if somebody feels the need to step in during the presentation, what's the most effective way to do that? Sure,
I'll watch the screen for raised hands too. So the virtual hands probably the easiest to see because it's bright yellow. So thank you. What I would like to start by doing is just to make sure, I had sent an email last week. There's a lot of information posted online because this committee has engaged in significant work on this topic previously. So I sent out a link to all of that information. It is linked both off of the committee materials page, and much of the information is on the webpage for the task force that 2 years ago now, almost got together and started working on this issue. So that is a great place to go for information. It'll start you down a rabbit hole of many other sources of information. And I'm going to be screen sharing in a little bit. One of the things that the task force did was to put together some charts which try to summarize in relatively straightforward form some of the basic tenets of Indian law, and it's separated out into several subject areas. So we're going to start today, once we get into the meat of this, with criminal law, and there's a specific chart for criminal law. So those are all posted on that website, and I will again screen share today as we get started. But before I get into the specifics of the various topics, I do want to situate folks to how we got where we are. Many of you know, and if you don't know, it's okay, we'll get there, that the tribes in Maine, and there are 4 federally recognized tribes in Maine, are in a bit of a unique position compared to how many other tribes in the United States are governed. The status of the tribes that are located in Maine today is governed by 2 big pieces of legislation, one federal and one state. So on the federal side, we have the Federal Settlement Act, and on the state side in Maine, we have the Maine Implementing Act, and they travel together. So kind of one doesn't really work without the other. So if you have not yet taken a look at, I would start, I think, with the Implementing Act. It would be worth your while to take some time and to just read it. And it's long, and it can be some rough going, but that is a good place to start. And you will find a copy of the Implementing Act in the Tribal Task Force report on the task force website. So those acts date to 1980. So we are 40 years in at this point. And those acts came about in a sort of interesting way. In the 1970s, there was a movement nationally for tribes to assert greater autonomy and self-determination. And that movement also happened in Maine. And in 1972, there was a piece of a lawsuit filed, and the name of the case is Passamaquoddy v. Morin. So this was filed in 1972, and the Maine tribes were requesting a declaratory judgment and a preliminary injunction. And what they were asserting was that the treaty, there was a major treaty signed in 1794. And what the tribes were asserting was that that treaty essentially wasn't valid under a federal law called the Non-Intercourse Act. And it wasn't valid, the assertion went, because the federal government never ratified it, which is a requirement for treaties under the Non-Intercourse Act. So that case, it took a while, and the state eventually intervened as a party defendant. But in district court, eventually it was determined that the tribes did fall under the purview of the Non-Intercourse Act, and there was, in fact, and this was, I think, the most important thing, a trust relationship between the federal government and the tribes, and this was really the first time that this had been well established in court. So what this meant then, and was that, and this was, I should say, this was affirmed in the First Circuit. So what this meant was that the tribes then were able to go forward and assert claims to a significant amount of land in the state of Maine, quite a lot of land in the state of Maine. So at this point, negotiations began between the state, the federal government, and the tribes to try to sort out these land claims and to come up with a negotiation. And it wasn't just the land claims that ended up being sorted out in these negotiations. It was a whole slew of things fell under the Settlement Act. So criminal jurisdiction, civil jurisdiction, hunting and fishing, all of these areas are covered under the Settlement Act. So it was in 1980 that the parties did finally agree to a settlement, and that was first the Maine Implementing Act was passed, and then the Federal Settlement Act followed, and that was what established that law was now the governance for the tribes in Maine. That is so brief and barely touches anything, but that is how we got to the Settlement Act. Now, since the Settlement Act has been in place, there has been quite a lot of litigation about what exactly it means. Some of the language is a little hard to, when you read it, it can be hard to figure out exactly what it's saying if you're coming at it cold. So there has been over the years quite a bit of litigation to try to determine what the contours of the Settlement Act are, and what rights are held by the state, what rights are held by the tribes, and what is a little unclear. So over time, there has been, at least particularly recently, movement towards changing the Settlement Act to reestablish in law tribal sovereignty. And so in it was July of 2019, a task force was put together to try to get legislators, the state representatives of the state, including the Attorney General's office and the governor's office, as well as other executive branch members, to sit down with tribal leaders and to try to come up with some recommendations. This task force met from about July of 2019 to December 2019, met many times, spent a lot of hours going through this material, and ended up coming out with a quite extensive report of 22 recommendations. That report then went to the Judiciary Committee last session, and the Judiciary Committee began reviewing this information, was looking at some draft legislation, and actually did, just kind of at the 11th hour as things were heating up with the pandemic, did come out with a vote, and ought to pass as amended vote, but it never got to the floor because of the adjournment because of the pandemic. So the authority then to report out legislation from the task force expired. So there will be new bills introduced to keep some of this work going. So in anticipation of that, here we are. So we are kind of ramping this work back up again in this committee. And knowing that there are new members of this committee who are not familiar with this topic area, we are trying to build familiarity. And I see Representative Moriarty has a hand up.
Sam, I'm sorry to have interrupted you so early, but I just need a quick question on legal history here. I reviewed the summaries of the three major decisions from the 70s, Morton, Dana, and Bottomley. And then, of course, in the following year, 1980, you had both the Federal and the Maine Act. In light of those two statutes, are those cases still considered to be good law, as attorneys use that phrase?
I could try to answer, but I'm willing to bet there's like 6 people on this on this call who probably could offer a better answer than I would. So if either an AG or a tribal attorney has a succinct answer to that, perhaps I could ask one of them to take a shot.
This is Allison Binney. I'm willing to try, Representative. So the way I always explain federal Indian law is, tribes are extra constitutional. They pre-exist the U.S. Constitution and they're sovereign. But because the federal government has, been formed, and the U.S. Supreme Court has found that tribes are sovereign, except to the extent that any of their rights have been taken away by the federal government. So states can't take away any rights, only the federal government can. So those cases are still good law unless aspects of them, and there have been some aspects, have been directly addressed via federal legislation. So when you read the Maine Implementing Act, you have to read it at the same time that you're reading the Federal Settlement Act, because the Maine Implementing Act on its own has no impact, no authority to restrict the rights of tribes. It's only because the Federal Act passes that then confirms the Maine Implementing Act, that the Maine Implementing Act has any authority over the tribes or any sort of restrictions on it. So it's really about tribes having full inherent sovereignty unless it's restricted. So it's really about, which is what makes it complicated here, is about reading the Federal Act and the State Act together to determine what restrictions on that sovereignty have been. So on those 3 cases, yes, they're still good law, but there are aspects of them that have been addressed by the federal law in combination with the state Maine Implementing Act. And so that's what makes it complicated.
So what I would like to do now is to move to talking about some of the substantive areas that we anticipate will be covered in some of these bills that the committee will see. And we thought that the area we would start with, and just to clarify, we did have a pre-planning meeting with tribal attorneys and with representatives of the AAG, so everybody's sort of on the same page as where we're going in this education session. And we thought it made sense to start with the area of criminal law And one of the reasons is that this is actually an area where the state representatives of the state, as well as representatives of the tribes, have made some pretty significant progress in coming to some agreement as to where changes in the law need to occur. So I am going to screen share a chart. And I do recognize when screen sharing, it can be sometimes harder to see hands go up. So perhaps my colleague Peggy could watch out for hands and just let me know if I'm missing somebody. All right. Okay, so you should be seeing a chart, and at the top it says location of criminal conduct. And if you're not, then we have a problem, but it's okay. Okay, so just to reiterate, these charts were prepared as part of the task force work and also for the Judiciary Committee last session. They don't represent any specific opinion. They are intended to be as objective as possible as one can be in this area. So they are intended to be nonpartisan and objective statements of the law as it currently sits. And we tried very, very hard to do that. So when we're talking about criminal law, it really matters where an offense occurs. That is absolutely, it is like the first question you want to ask when you're talking about criminal law in the context of tribal law. So we have this laid out with 3 columns, and I'm going to focus on the first 2 columns, but I think it's sometimes helpful to see the 3rd column so you can see where the thinking of the task force and the Judiciary Committee was. But I'm going to kind of ignore that column for the moment. So the first 2 columns, the first one is what we're calling default federal Indian law. So by that, we mean what the law, and that would be case law as well as any federal legislation that governs tribes in the absence of any state implementing act or any sort of other unusual circumstance. The second is the law currently applied in Maine, so the law that you would see reflected in the implementing act. So the first question is, what is the land over which tribal courts have specific limited criminal jurisdiction? When we talk about federal Indian law, we talk about offenses occurring in Indian country. This is actually a phrase that is defined in federal statute itself. And it means any land that's in the limits of a reservation, dependent Indian communities, which is also a defined term, as well as Indian allotments, the titles of which have not been extinguished. In Maine, in the implementing act, it's a little different, and you need to look at each of the language that applies to each of the tribes specifically, and this is a recurring theme in the implementing act. So the Passamaquoddy Tribal Court has jurisdiction over certain defined offenses, we'll go over them in a bit, that are committed on the reservation of the tribe, or potentially what is termed the extended reservation of the tribe. The Penobscot Nation Tribal Court has jurisdiction over the same terminology is used, so reservation and extended reservation. Now, the Holton Band of Maliseet Indians Tribal Court has jurisdiction over certain criminal and juvenile offenses committed on Holton Band jurisdiction land. So it is more defined in the implementing act than it would be in default federal Indian law. That's the take home from that. Just to check, can you see when I scroll down? Is it scrolling did it scroll with me? Okay, good. Let me make sure it wasn't staying and I was moving on. So you'll also note that the Micmac Settlement Act, and I should certainly have mentioned this before. The Micmacs have their own settlement act. It is separate from the settlement act that applied to the other tribes. And it is a separate piece of federal legislation, is a separate implementing act in the state side, but we do cover it in this chart as well. And the Micmac Settlement Act is a little more limited, so it does not authorize actually any authority of the Aroostook Band of Micmacs to establish a tribal court. Okay, so besides where a crime occurred, it matters very much who committed the crime and who the defendant, or who the victim was. That is the other major factor in determining jurisdiction over a crime. So before I move on, before I keep going, any questions? I want to make sure I'm not just barreling over this and losing people. Okay. All right. So the first case is the case where you have an Indian defendant and an Indian victim, or a victimless so-called crime. So under default Indian law, and you're going to see some qualifiers throughout this, so possibly, mostly, sometimes. So this is a situation where there is a possibly. So there is possibly concurrent jurisdiction, and we're talking about tribal courts. So the jurisdiction of tribal courts is possibly concurrent when there is a major crime committed against an Indian victim. Now, what is a major crime? A major crime is defined in the Major Crimes Act, which is a piece of federal legislation, and it includes murder, manslaughter, kidnapping, maiming, a felony under Chapter 109A, sexual abuse, incest, aggravated assault, assault against victims under 16, felony child abuse or neglect, arson, burglary, robbery, and a felony under Section 661, which is theft. So those are the major crimes. And you would typically see the federal government pursuing those, but it is possible that tribes do in fact have concurrent jurisdiction when there's an Indian victim. It is clear that tribes have exclusive jurisdiction over other quote unquote non-major crimes committed against an Indian victim. There is also jurisdiction, maybe exclusive, maybe concurrent, over victimless crimes. The defendant, this is I think an important piece, an Indian defendant to fall under this category does not need to be a member of the specific tribe with jurisdiction. So you could have an Indian victim who is a member of an entirely different tribe than the tribe upon whose land the crime takes place. There are some qualifications for penalties. There are maximum penalties that may be imposed by tribal courts, and there's kind of two categories of those. For any one offense, there's a maximum penalty of $5,000 fine and 1 year of imprisonment, or a $15,000 fine and 3 years imprisonment if certain due process protections are followed. And those are that language comes from the Tribal Law and Order Act of 2010. There's also a maximum aggregate penalty of 9 years. And for juveniles, if a tribal court has jurisdiction over the corresponding adult offense, it would also apply to juvenile. That was the simple part. Now, what about under the Implementing Act? So it is different in the Implementing Act in Maine than it is under federal default Indian law. And again, there's some variation among the language as it applies to each of the tribes. For the Passamaquoddy Tribal Court, there's exclusive jurisdiction over crimes if the crime takes place on the Passamaquoddy Indian Reservation. There are maximum penalties And the defendant and victim must each be a member of the Passamaquoddy tribe, the Holton Band of Maliseet Indians, the Penobscot Nation, or the defendant is such a member and it is a victimless crime. I think Kim, hand.
Hi, Sam. Thanks. You're doing a really great job of going over all this. I just wanted to point out that this chart was created during the task force process. And so there actually was a law that was passed during the 129th legislature that did adjust the jurisdiction of the Passamaquoddy Tribal Court. So I just want to note that so that this information right now, and I think recommendation number 2, equate the criminal jurisdiction of the Passamaquoddy Tribal Court with the Penobscot Nation Tribal Court. That's already been enacted into law.
Thank you so much. I had a note at the end because I was this morning trying to update some of that and didn't quite get to the specifics, but LD 766, it was a piece of legislation that passed last session. So that, and that was looking at the major part of it was updating some of the language around domestic violence crimes to fall in line with VAWA. So this chart doesn't reflect that because this chart is a little historical, but I did try to make some notes in my notes to direct you to that bill. So that is important. Okay. So the Penobscot Nation Tribal Court, and as Kim said, it probably makes sense to just say the Passamaquoddy Tribal Court language was updated to be in line with Penobscot language. So the Penobscot language is a little bit broader in that the defendant and the victim must each be a member of any federally recognized Indian tribe, nation, a band, or group, as opposed to a member of one of the main tribes. The Holton Band of Maliseet Indians Tribal Court is also a little bit different in that there is language around membership in the Holton Band. There was, at least when this chart was written, it wasn't clear whether jurisdiction would extend if defendants were members of the Passamaquoddy, Penobscot, or Penobscot Nation. Let's see. Okay, so that's one class, one combination of victims and defendants. So the second combination to look at is cases in which you have an Indian defendant and a non-Indian victim. So under default federal Indian law, it is unclear if there is concurrent jurisdiction again over when it is a major crime in question. It is, however, very clear that there is concurrent jurisdiction with the federal courts over non-major crimes, other crimes. Under the Implementing Act, there is no tribal jurisdiction when you have an Indian defendant and a non-Indian victim. So that's an area where there's a clear difference. When you have a non-Indian defendant and an Indian victim, generally, tribal courts lack jurisdiction over non-Indian defendants. There's a big exception, and that is for domestic violence cases under VAWA. There's concurrent jurisdiction with either state or federal courts over domestic or dating violence. And so the a non-Indian defendant residing or employed in the tribe's Indian country, or, one who is a spouse, intimate partner, or dating partner of a tribal member will fall under the tribe's jurisdiction if the victim is an Indian. There's some due process requirements and some maximum penalties that apply. Previously, prior to 766, there was a gap or a discrepancy in the implementing act, and that there was no tribal jurisdiction over even domestic violence cases. 766 did change that. So that is if you're doing some background reading, looking at LD 766 from last session would probably be on your list. All right. So just very briefly, non-Indian defendant, non-Indian victim takes place on tribal land under default federal Indian law and the implementing act, no jurisdiction. Okay, so that's tribal courts. Now we have our second set of courts, which are state courts. For default federal Indian law, it's pretty easy. There's no state jurisdiction at all. When you have an Indian defendant and an Indian victim. In Maine, under the implementing act, except for offenses that fall under the exclusive jurisdiction of tribal courts, state courts have jurisdiction over all non-federal adult crimes and juvenile crimes. There is another exception to tribal court exclusive jurisdiction, and that is that a state court can enter a conviction involving a crime that is within the exclusive jurisdiction of a tribal court if the crime is a lesser included offense of a crime charged in state court. And I admit, I don't know how often this happens, but it is something that is provided for. Okay. Next group, state court. We're still in state court, and we're talking about Indian defendants and non-Indian victims. Under default federal Indian law, no jurisdiction. Under the implementing act, exclusive state jurisdiction. So this is an area where you see, again, pretty significant differences. Same thing when we're talking about non-Indian defendants and Indian victims, and non-Indian defendants and non-Indian victims. Or rather, the last one, sorry, is exclusive state jurisdiction in both cases. All right, the last set of courts are federal courts. So all defendants, the status of the victim not being relevant in this case, there is exclusive jurisdiction under default federal Indian law over general federal criminal statutes that are effective throughout the nation and that apply to all persons, whether or not Indian. Under the implementing act, that is the same. There's not the state implementing act it doesn't abrogate any federal law. If you have an Indian defendant and an Indian victim in federal court, there's concurrent jurisdiction probably over major crimes committed against an Indian victim. There's no jurisdiction over other crimes, and it is unclear whether jurisdiction exists over victimless crimes committed by Indians. Under the implementing act, no federal jurisdiction, that is the states. And so these are kind of the flip of what we were talking about before when we're talking about tribal courts and state courts. But Indian defendants, non-Indian victim, under default federal Indian law, you have jurisdiction over all crimes unless the defendant's been quote unquote punished by the local law of the tribes. Non-Indian defendant and Indian victim, exclusive jurisdiction under default federal Indian law with the VAWA exception. Non-Indian defendant, non-Indian victim, or no victim, no federal jurisdiction when the victim's a non-Indian, and unclear whether federal courts have jurisdiction in victimless crimes. And then juvenile defenses are outlined at the bottom here. They tend to mirror adult offenses. So this is a lot of information. It's a whole lot of information. It's probably not something you are going to internalize without reading it half a dozen times and reading more about it. But this is a good reference for when you are reviewing legislation and you want to know, in the absence of the implementing act, what would things look like if we got rid of certain language that we currently have in state statute? What's the default? So what are you left with? And this is a good way to remember some of that. There are some other issues related to criminal jurisdiction that we wanted to pull out that are kind of don't fall within that first set of charts. The first is legislative authority to define criminal offenses, which is a little different than the court jurisdiction. Under default federal Indian law, the tribal government does have authority to define all the crimes over which that court has exclusive or concurrent jurisdiction. But under the implementing act, tribal governments generally lack that authority. There is an exception, and that relates to the authority of the Passamaquoddy tribe and the Penobscot Nation to promulgate and enact ordinances relating to the taking of wildlife within their territories, as well as the taking of fish in any pond less than 20 acres of service area within their territories. Otherwise, it is the state that defines crimes. Now, state legislatures have legislative authority only to define the crimes within their court jurisdiction. The Maine legislature, though, except where there's that authority regarding hunting and fishing ordinances, has the authority to define crimes. Congress, of course, has legislative authority over Indian country. In Maine, it's a little different. Congress has legislative authority over Indian country, but they have waived the applicability of several federal criminal laws and essentially ceded that authority to the state. All right. Another issue that comes up often in discussions of criminal jurisdiction in the context of tribal law has to do with double jeopardy, because you're dealing with a couple different sovereigns. So under the dual sovereignty doctrine, successive prosecutions by a tribe, state, and the federal government for the same conduct do not, in fact, violate the Fifth Amendment. There's an exception. By statute, an Indian defendant may not be prosecuted in federal court for a non-major crime committed against a non-Indian victim if the defendant has already been punished under tribal law. Under the Maine Implementing Act, under the dual sovereignty doctrine, again, successive prosecutions do not violate the Fifth Amendment. Also, successive prosecutions by the state and the tribes for the same conduct are specifically authorized by statute and do not violate double jeopardy prohibitions under the Maine Constitution. So that is it for my presentation on criminal law. And I might just leave this chart up so we can go back and reference it if folks have questions about any of this. And again, understand that I understand that this probably didn't all get synthesized, but it is a good place to start. So I'm gonna pause there for a minute and see, one, if any members have questions, but also if there's anything important that I missed or any clarifications that should be made by the experts on this call.
Sam, could we start with clarifications by others before we move on to questions from the committee?
Absolutely.
And I'll let you call on people because I can only see the screen that's being shared.
Okay. I see Representative Hagan's hand.
Hi there. Last time around, I had difficulty grasping or understanding the double jeopardy concept or the lack thereof. Could you go into a little bit of detail so I can get my brain wrapped around that one?
Sure. And so I'll do my best, and then when I miss something, please correct me. So the issue is whether or not you can be punished more than once for the same crime. So the dual sovereignty doctrine has to do with, so you have a tribe which is sovereign, you have a state which is sovereign, you have the federal government. So you essentially have three entities that could punish you for something. Now, generally that's not going to happen. Usually it is worked out between those entities who punishes who. But I think the point is that the possibility for multiple punishment exists. I see that Corey Albright has his hand raised, so probably has something better to say about this than I do. I think you're muted, Corey.
Yeah, no, I apologize, Sam. I did not mean to interrupt you or to interrupt your response to the representative's question. I have just another point that I wanted to make after you've finished with Representative Hagan.
So I think that the thing to know is that the possibility exists for multiple rounds of punishment for the same offense, but in practice, that doesn't mean that that always happens. It could happen, but from what I understand from folks who do this work, it is typical practice to sort out between the entities that have the ability to prosecute an individual to sort out who will take that baton. Yeah, well, I will move to Mr. Albright.
Thanks. I guess I just wanted to go back, I think, to the very beginning of the discussion, Sam, when you were talking about the definition of Indian country. Because I think my experience before the committee is it's really important for all the representatives to know kind of what geography we're actually talking about when we talk about these concepts, and what are the specific lands where we have to sort through this flow chart to understand how the law works. So, I'll just say that on that, the website, and Sam, I know you can point everyone there are some nice maps because that show, basically they show the tribal reservations, and then they show the lands that are held in trust by the respective tribes, for the respective tribes by the federal government. And as folks may know, Indian lands in the United States are very frequently held in trust by the United States for the benefit of the Indian tribe. So the fee is technically in the United States, but it's held in trust for the tribe. So trust lands, as well as lands within the exterior boundaries of a reservation, that's really your shorthand for Indian country. And that's where these rules apply. So if you're curious, whether or not your district, has lands, what's the scope, then I think it'd be great for everyone to start, because everything we talk about over the coming months, whether it's civil or criminal, it's all grounded in sort of that land base.
I will, after we're done this afternoon, I will mail or email links to those maps out to the committee so you can take a look at them. It does help to be able to see where it is we're talking about. And Representative Hagan, did I answer your question, or is there more we could?
I apologize. It just seems to me, I don't understand why. I've had it explained to me before, and I apologize to everybody here. It seems to me that if the U.S. Constitution says you cannot be tried for the same crime twice, then you cannot be tried for the same crime twice. And yet, under this, I'm told that you can be. And so I guess I have a brain block.
Yeah, Representative Hagan, it's Allison Binney. I can try to describe it as, like the U.S. Constitution does say that, so you can't be tried for the same crime by the same government. So like you can be tried by the feds and you can be tried by the state government for the same crime. They would probably be different offenses that you get tried for, but that exists now. And when you throw tribal government in there, so if you commit a crime on Indian lands, it just basically opens the door for a third government to try you. So when Sam's saying like there are possibilities for somebody to get tried and multiple times, it's basically just you're adding in a tribal court system on top of the state and federal system. So like the federal and state system, it doesn't happen often, but there are times when a perpetrator does get tried by the feds and by the state. And so just when there's a crime in Indian country, you're just throwing in a third government.
All right, I thank you for that.
Assistant Attorney General Pedwar, and I think had a hand up too.
Yes. So, in just in addition to what Allison said, I also sometimes get confused on double jeopardy concepts, but I try to distinguish between conduct, and then the applicable law, and then the government that has enacted that law. So that, you know, a single act that occurs within the state of Maine could be punished under federal law or under state law. And the punishment could be imposed by two different governments. So I try to distinguish between the conduct and then the law that applies to punish that conduct.
Representative Babbage.
So I'm on, I guess. Thank you very much, Sam. And while we have these wonderful attorneys here for the tribes, I just wanted to, I appreciate Representative Hagan's line of questioning. I wasn't going to go there, but I guess what I'm asking is, elsewhere in the country, the thing that I would be concerned about would be that one community be unsatisfied with the treatment of a defendant by the other community, and therefore decide to prosecute within their own jurisdiction. Do you have any experience of that elsewhere in the country? Thanks.
I would say that this is Allison Binney, Representative Babbage. So I would say yes, on all sides, right? There are, you know, Native Americans who feel like they get punished more harshly by state and federal governments than they do in tribal governments for crimes coming from the same actions. But on the other hand, I would say that there are times when, you know, tribal courts have limited jurisdiction to sentence people and fine people. So what I see more of is a tribal court prosecuting somebody to the extent of that tribe's jurisdiction, which is oftentimes limited and more limited than what a state court could do. And then the tribe or the federal court, and that the tribal court works with the state and federal prosecutors to bring a second prosecution in either state or federal court to try to, you know, prosecute a crime to get it to where it should be. So tribal courts just have less of a docket typically, so they can, you know, prosecute crimes faster. In typical, I'm just kind of speaking generally because there are probably some states that prosecute quicker, but definitely I've not seen federal courts prosecute quicker than tribal courts. But tribal courts, because they just have a smaller docket, can usually prosecute crimes quicker, but they have, you know, less ability to sentence people. And so what they typically will do is they'll work with the state or feds to eventually have that person also prosecuted to try to get it to a level that that person, if they are successfully convicted, would be serving a sentence or paying a fine that's similar to what they would have done if they were prosecuting federal or state court. But yeah, there's always people who challenge jurisdiction in both instances, right? There's always Indians who challenge the jurisdiction of state courts to prosecute them, and federal courts, you know, oftentimes because tribal communities tend to be more community oriented and therapeutic in a lot of their, you know, criminal, you know, conduct and offenses, because those people, whether they're Indians or not, they live in the community, they are coming back to that community, they're either married to tribal members or have tribal member children. So a lot of tribal courts tend to be, I would say, more therapeutic in some of their punishments, and sometimes that doesn't fit within the larger community's, you know, standards of criminal punishment. And then there's non-Indians who, you know, consistently challenge the jurisdiction of tribes to prosecute them.
Representative Babbage, you're muted.
Thank you very much for that answer. I appreciate it. It's very detailed, and you're always very complete. I appreciate that. So in your experience then, there's not a movement of double jeopardy advocates saying this is an area of abuse, or would you say not?
Well, I'm gonna definitely ask if Mr. Taub and Ms. Pat Warden wants to add anything here. There's always on both sides of the issues, there's always advocates for people. So there was recently, I believe there was recently an Indian, I believe it was Navajo Nation, but there was recently a Native person who got sentenced to death, and there was a movement, not within tribal court. But there was a movement, this was in federal court. So there was a movement by a lot of tribes to stop that. There was a feeling, even amongst the family of the victim, that that person had been punished enough, and that, it wasn't, they just did not believe in taking the life. So there were advocates, for that. And vice versa, there always are some advocates against double, or expressing concerns of double jeopardy. And I've seen that both in Indian country, people who are concerned about people getting tried by tribal courts and state and federal, but there's similarly the same advocates who just generally have concerns about double jeopardy regardless. So it's not unique to Indian countries, what I would say, the advocates that I'm aware of, but I would defer to see if either Mr. Taub or Ms. Pat Warden has any thoughts on that as well.
Thank you for that.
Do either of the AAGs want to speak to that? Okay. Are there any other any questions about anything in this chart or related to criminal law from members of the committee? Oh, Mr. Albright.
Yeah, I just wanted to say, kind of briefly, touching on the double jeopardy question, is that in my experience, the county prosecutors, local prosecutors, state attorney generals, they're in close communication with the tribal prosecutors. So when there's a concurrent jurisdiction situation, as Representative Babbage said, there may be times when the community has extremely strong views on how that should proceed. But in my experience, when there is an option, whether tribal or local county prosecutor can pursue a case, they're usually in communication to decide, well, who's got the resources, how quick can this get done? Are we satisfied with what you're going to charge? And so you don't see a lot of double prosecutions on like, say a fish and game criminal violation or something where there's a concurrent jurisdiction issue. So I just think it's important to kind of remember that the governmental officers of the respective governments, they have relationships, right? They work together, and that's how they, protect the communities most efficiently and also preserve their respective, priorities and interests.
And I would just add just to that, there is a growing movement. It's been growing for the last 15 years to increase coordination between state, county, federal, and tribal courts to share information and coordinate on these types of issues. And so Congress has passed more, I would call technical fix bills, including last year, to sort of clarify and streamline access to both state information systems, tribal information systems, and federal information systems. So law enforcement and the courts can better coordinate on these types of prosecutions. The American Bar Association has its own Indian law section to look at issues like this, and the Federal Bar Association does as well. So it's really about bringing, judges and lawyers together. And in Maine, when the legislators passed and the governor signed the kind of the bill last year about the restoring back to tribes some of the domestic violence crime authority, there was a provision in there. I believe it was that one, though I'm looking at Ms. Pat Warden wondering if it was that or was it something else, but there's something in there about sharing information as well, that the tribal courts will share information with the state. So information sharing is important. The federal Department of Justice has an Office of Indian Tribal Justice. So it's really about coordination, and there's been significantly more resources that have been put into that over the last 15 years nationally and in most states.
Yes, to add on what Ms. Binney said, in 766, there was a provision that was added to the Implementing Act, which requires tribal courts to provide conviction information to the State Bureau of Information so that those convictions show up. Right now, those convictions are not being transmitted into SBI. And my understanding is there's some conversations going on right now in order to begin that process of how the tribal courts will begin sending information to SBI. And I want to be clear, that's just for tribal court convictions. Tribal police departments, I believe, already have access to SBI, so they can look up information in that database to find out if somebody has an arrest or other information like that. It's just there's that gap right there right now that is that the legislature just is plugging with 766 of getting conviction information into SBI.
Representative Babbage.
Yeah, thanks. I guess I'm off. Thanks, Sam. I just wanted to ask Mr. Albright if he would just define for us, you defined the lands for us, and my understanding is that Indian country is a federal term. We use tribal lands, I think, in the task force recommendations, which included trust lands and restricted fee lands. Restricted fee different than fee lands? And are these lands just purchased by tribes, or could that be individuals that could eventually go into the fee to trust process? Just a clarification on some of those terms, if you could help us out.
So restricted fee lands are a unique class of lands where the fee is held by either an Indian nation or a tribal member, but there is a federal restriction on alienation imposed on that. So it's slightly different from trust lands, because trust lands, the US actually holds the fee in trust for the benefit of the tribal member. I'm not sure, and I will defer to Representative Newell, Ambassador Dana, Ms. Binney. I'm not sure if there's any restricted fee lands in the state of Maine. There are some states like Oklahoma where there's a lot of restricted fee lands, and it has to do with various congressional enactments in the 20th century and the 19th century. But we're not going to go down that rabbit hole. So there is a slightly different trust. You know, the fee is the nature of the title is slightly different, but restricted fee lands as a practical matter are treated the same as trust lands under federal law for generally speaking, for jurisdictional purposes.
I guess what I'm asking is, are there not restricted fee lands, but are there fee lands in Maine that could become or that are designed to become part of the trust process?
Not
restricted fee and fee lands are both exist. Is that right? Separately, I mean.
Yes, they're very separate. So if an individual tribal member purchases a piece of property somewhere, that's fee land, just as if I came and purchased a piece of property. You need something special like an act of Congress to create restricted fee land. If somebody, you know, there is the process of putting land into trust, and there are specific provisions of the Maine Indian Claims Settlement Act that address the tribes, you know, acquiring lands and putting those lands going into trust. But I think I'll leave it there and see if anyone else wants to jump in and add anything.
So as far as our jurisdiction that we're talking about here, that does not apply to just fee land, just to trust and restricted fee land. Is that right?
The only difference there is if and one of the other attorneys may want to speak to this, is on an Indian reservation, a body of land that's been defined as an Indian reservation, fee land within those boundaries, if it is owned by the tribe or a tribal member, all that land in there stays Indian country, okay, within the boundaries. But if you're outside the boundaries of a reservation, then fee land is not going to have any of these rules applying to.
Okay, thank you.
That's
Thank you.
right. This is Allison Benny again. The Maine Implementing Act, there are fee simple lands. So there are restricted fee lands in Maine. They are typically, I think they're only just the initial reservations. The initial reservations, I've not looked at the underlying titles, but based on the laws, the initial reservations are likely in what's called restricted fee status, which is just reservation status. And then any lands that the tribes have acquired since those initial reservations are, some of them are eligible to be put into trust status and have been put into trust status. And trust status is when the lands, the underlying title, is held with the federal government, but for the benefit of the tribe, whereas restricted fee lands are titled directly held by the tribe. And it is typically just initial reservations. Fee simple land is the land like what you and I buy, and tribes can buy that too. It doesn't change any of the jurisdiction, just like when you and I buy land, it doesn't change any of the jurisdiction status. Under the Maine Implementing Act, each tribe is treated differently when it comes to taking fee simple land and putting it in the trust status. Penobscot is capped at a certain number of acres, and it's mandatory that certain lands go into trust status if the tribe so desires, but only within certain geographic areas. Passamaquoddy has their own provisions towards them, and Holton Band has their own provisions towards them. So each tribe is treated differently in the Maine Implementing Act. Under default federal Indian law, tribes can acquire lands in fee simple, and then they go through a federal regulatory process to apply to try to get those lands into trust status.
Thank you so much.
Are there any other questions about anything pertaining to criminal jurisdiction? Okay. I think if it is okay with members, what I would like to do next is to go into land use. We could talk about civil jurisdiction writ large, but that is a little hard to grasp out of context. So we thought it might help to go through a couple of the more specific topics that fall under civil jurisdiction generally, such as land use, to get our feet under us. So I'm going to unshare my screen for a minute while I load my next chart, because I'm not very good at doing it while I'm sharing it. Close that.
Sam, I think that's a good plan to move forward.
Okay. Yeah, just the trying to understand civil jurisdiction without any sort of examples is hard. All right, I'm gonna reshare here. So thankfully this chart is much shorter than the other chart. I don't know that the topic is any easier, but there's less words. So again, here we've got a column for federal law and a column for the Implementing Act and Settlement Act. So they're not split into categories. These are some basic tenets, and feel free to ask questions about these as we go through them. So this is an area where there is a big difference between the default federal Indian law and the status under the Implementing and Settlement Act. Under federal Indian law default, tribes generally retain exclusive rights to the use of the land and resources that fall within their territories, unless those rights have been otherwise abrogated by treaty or by statute. I'm talking about federal treaty or federal statute. There are many federal environmental laws that provide for delegation of regulatory authority to the states, however. So that is subject, of course, to minimum federal standards and to the oversight and the veto authority of the EPA. So for example, the EPA delegates to states the authority to issue discharge permits pursuant to the Clean Water Act. States generally do not have the authority to implement federal environmental statutes within Indian territory. In the environmental context, and this is a quote from Cohen's Handbook of Federal Indian Law, which is a very large book. In the environmental context, Congress has authorized Indian tribes to assume primary regulatory authority or primacy for administering most of the federal environmental programs in Indian country. And various federal laws have provisions that authorize EPA to treat Indian tribes essentially as states for the purpose of administering federal environmental programs. So it's called treatment as a state, and that is it's a common tenet. Tribal water quality standards may also be enforceable in non-tribal areas. And so that's what for example, if you're talking about the effects of certain industry on waterways and how it affects water downstream. So that's the default. In Maine, it's different. Under the Implementing Act, essentially the background rule is that Maine law on natural resources governs the tribes and their territories. And this has been an area in which there's been a fairly significant amount of litigation. So this was a holding in Maine versus Johnson, which was a First Circuit case from 2007. And that had to do with discharge draining into tribal waters. So except as otherwise provided in the Act, all Indians, tribes, and bands, and any lands or natural resources held in trust are subject, and this is a quote from the Implementing Act, to the laws of the state and to the criminal and civil jurisdiction of the state to the same extent as any other person or lands. So there's both case law and the statute itself that speaks to this. There is also language, and this is getting into the part of the Implementing Act that is the hardest, I think, to grasp, but I'm going to read it to you just to introduce it. Two sections of the Implementing Act. Section 6.8 states that, except as otherwise provided, the laws and regulations of the United States, which are generally applicable to Indians, Indian nations or tribes, or bands or lands owned or held in trust for Indians, Indian nations or tribes or bands, shall be applicable in the state of Maine, except that no law or regulation in the United States which one accords or relates to a special status or right of or to any Indian nation, tribe, or band, won't read the rest of it, which affects or preempts the civil, criminal, or regulatory jurisdiction of the state of Maine, including without limitation laws in the state relating to land use or environmental matters, shall apply within the state. Now you can read that and think, well, what does that mean? Which I think is probably what most of us think when we read that at first. But that is a really important section, and it has been the cause of a fair amount of consternation, I think, on both sides, as to what exactly this means and to what extent does it apply. There is a corresponding provision, which is 16B, which states that the provisions of any federal law enacted after the date of enactment for the benefit of Indians, Indian nations, or tribes, which would affect or preempt the laws of the state or Maine, shall not apply. So these two provisions sort of work together. One applies to the anything in effect at the time that the act was implemented, and one that applies to after the fact. So together, in terms of when we're talking about environmental regulation and land use, essentially what this means is that state law is controls. So this is an area that the task force looked at and recommended that the states cede its authority essentially, and that the federal default rules would apply, so that tribes could then apply for treatment as a state status with the federal government and have greater autonomy over administering federal environmental programs that impacted their lands and have more direct control over their lands. So perhaps more than any other area, this is an area where there's a very stark contrast between the default federal Indian law and the implementing act. It is very different. So I will stop there for questions or discussion or clarifications, corrections.
Sam, excuse me, Sam, would you like to ask first for people who want to be recognized for clarifications?
Sure. Representative Rackett.
I think I would be clearer if you told me an example of when there is a conflict or when there isn't, without regard to what happened to it. I mean, just where is the place where this would rub? I don't quite understand. I understand the criminal and civil stuff better than I do this land use piece. So.
Much of it has to do with, a lot of the litigation has been around water. And perhaps I could invite either a AG or a tribal attorney to talk about some of this. And I know some of this is kind of active litigation, so I don't want to
Well,
get too far into
it
that.
might be, yeah, it might be enough for you to just tell me that this is the area of the law where the whole issue of the rivers and so forth come into play.
Yes.
Okay, that's enough. That's all. I just wanted
Representative Hagan.
Yep, I have a question, just clarification so that I understand better. Under federal Indian law, if the tribes own, say, some land on part of the river, I live right on the Penobscot River. I'm in Hamden, just south of Bangor, and let's say they own property in Winterport, which would be south of Hamden. They're under federal Indian law. Would that give them the ability to tell Hamden and Orrington, which are towns that are across from one another, we want a certain quality of water by the time it reaches us? And under the Implementation Act, that's not the case.
So this is Representative Hagan, this is Allison Binney. I would respond first by saying, remember, it matters if the land that the tribe owns in Winterport is trust or restricted fee land.
Okay.
Because if it's just fee simple land, it's completely under state jurisdiction. So just the fact that the tribe owns it doesn't mean they have any authority over it. Right. If the tribe gets it into trust status, under general federal Indian law, what it would mean is that the tribe gets a seat at the table, like absolutely gets at the table to be part of the discussions on the water quality standards. And I speak as a tribal attorney when I say this next part, because one of the attorney generals may think differently, but I think at least from my point of view is under the Maine Implementing Act, it is less clear, but in our mind, we should still have a seat at the table. But the Maine Implementing Act is less clear about that. But under federal Indian law, absolutely, if the tribe has trust land, they get a seat at the table. And not only do they get a seat at the table, the feds have some responsibility in providing resource, or federal government has some responsibility in providing resources to help mitigate any impacts to tribal assets, trust assets, which could include, sustenance fishing.
May I follow up?
Yes, yeah.
I appreciate that. I had trouble understanding it last year, and things came, very quickly, and they ended very quickly. So when you say seat at the table, do you mean, what does that exactly mean?
It would mean in kind of the easiest way I could describe it, that the state couldn't just enact laws or allow pollution into that portion of the river without at least having a discussion with the tribe to determine if there are harms to any tribal trust assets.
And could they make it, the tribes say, could they under federal Indian law say that you have to have a certain percent more clean than what is happening? Like we used to have mills on the river and whatnot. Would the town of Hamden or Orrington, which is across the way, be responsible for cleaning up or making it a certain percent better water?
They couldn't just demand that, but if they could show that there was harms to trust assets, then there definitely would have to be a discussion, but it doesn't necessarily mean that the towns of Hamden or Winterport would have any responsibility to that. Okay. The dialogue would more be at the state and federal level.
Well, I appreciate that. I just couldn't wrap my head around that one also. So thank you very much.
I just wanted to give either the Assistant Attorney Generals see if either wanted to weigh in on this point.
Yeah, this is Chris, and I'll let Kim also weigh in if she wants to clarify beyond what I'm about to say. But so under general federal Indian law, there are certain federal programs that can be delegated to the tribes. And so I think the one that we're probably talking about here would be the Clean Water Act. And so under the Clean Water Act, typically states are delegated authority to set water quality standards. And then those standards regulate sort of the discharges that various entities along a river or a water body can discharge. So whether that's, municipal water treatment programs or sewage treatments or commercial industry or mills or whatever. So under general federal Indian law, tribes can obtain that delegation. And then they have the authority to set water quality standards. And there is kind of open issues about the extent to which once tribes have that delegated authority, they then have the authority not only to set discharge limits for the actual water that's adjacent to their tribal lands, but also upstream, on the theory that discharges upstream are going to affect the water quality in their own area. Let me stop there and ask Kim if I missed something big or if she wants to add something to that.
No, I don't have anything to add at this time.
Does that help you, Representative Hagan?
It does. It was a pretty complicated thing, and court cases were brought in last year, and I just, in my mind, needed more clarification in this area. Thank you.
And the overlay I would add on that is the federal government. So, whether it's the state setting water quality standards or the tribes setting water quality standards, the federal EPA has an oversight over all of that, which is what complicates it, particularly if the tribes in the state don't come to some agreement.
Representative Babbage.
Yeah, thank you, Sam. I think all of this in the last year or two that we've looked at this specifically, it's opened my eyes to the dilemma of water quality on the Penobscot, and certainly I think the tribes have been in the right all along in their concerns and demands regarding that. I did want to say, though, doesn't this part of the task force recommendations also impact, such land uses as forestry and mining, which is actually the latter one is more of an interest to me. But and I know, as this applies to Western tribes, that may be much more. There may be examples of that, but I just wanted to say that water quality, forestry practices, and mining would also come under this particular area. Correct?
Yes, Representative.
Thank
you. Representative Newell.
Yes, thank you. Sam, I just have a question. In the document that you're using and the documents that the committee members received to follow along, is that different from the document that I actually have that lists the columns? Like for the example on land use and natural resources, you have federal law and then you have Maine, and then you have the task force recommendations. I guess my question would be, are you also presenting, Sam, the task force recommendations as voted on and voted out, or?
So, and that's Representative Newell, that's my fault. So the one we had posted was just a version where we hadn't added those yet. So what I will do for the committee is email everybody the versions that include the task force recommendations. And when I present on these in the future, I'll make sure that I'm using the ones with the task force recommendations. That wasn't it wasn't intentional. I just was using a version where we hadn't popped those in yet. But yes, I'll make sure that everybody has the charts with those recommendations included in that third column.
Yes, thank you, Sam.
Absolutely. Are there other questions or points of discussion around land use and natural resources? Okay. So I'm going to stop the share and then I'm going to pull up taxation and reshare. So again, this is a version that we hadn't included the recommendations yet, and I will send out a version with the recommendations. And I will just say this is the area that I find the most confusing, because tax law is confusing to begin with, and you overlap it with tribal law, and it becomes very confusing. Please do correct me if I'm misstating anything here. This is an area that comes up in discussion quite a bit. One, because it's confusing. Two, because it's money, which always involves discussion. So I wanted to go over what, again, the federal law here is, the default federal law, as well as the implementing act. And of course, there's different kinds of taxation. There's different people being taxed. And so this is, again, where it really matters who exactly you're talking about and in what context you're talking about those individuals, and also who is doing the taxing. So I'm going to break it down again by the entity and the individuals involved. So we'll start with the taxing entity being the tribe itself, and the individuals being taxed being the tribe itself, acting as a tribe, and the tribal members. So under default federal Indian law, tribes have the inherent authority to impose taxes within their jurisdiction. It is clearest when we're talking about taxation of members of that tribe. Under the Implementing Act, and this is one of the kind of quirks of the Implementing Act that is, I think, probably unique in the country. The Penobscot Nation and the Passamaquoddy tribe can enact and collect taxes as any municipality in the state can within their respective Indian territories. And the Maliseets do not have this language, so they do not have this powers or privileges of a municipality. I think this is language that has been talked about a lot. What does it mean to treat a tribe as a municipality? Because it's a unique construction, really. So that is the language as it applies to tribes and tribal members. As for taxation of non-tribal members, under default federal Indian law, this has been the subject of some degree of litigation, and there is case law around this. And case law tells us that tribes do have the authority to impose taxes on non-Indians within their jurisdiction, provided that they meet the requirements of a test from a case from 1981 called Montana versus United States. And it's an interesting case to read if you're interested in reading some case law on this area. And this Montana test goes beyond taxation and really into the area of civil jurisdiction generally. But essentially, if the tribe is taxing the activity of a non-member who has entered into a consensual relationship with the tribe through its commercial dealings, contracts, leases, or other arrangements. So they're doing business with the tribe. Or the activity of the non-member threatens or has some direct effect on the tribe's economic security or health and welfare of the tribe. You could see where that language might result in more litigation, and it has, to try to figure out what the contours of that language are. And I think the jury is probably still out there. In the implementing act, the Penobscot Nation, the Passamaquoddy tribe, again, can collect or enact taxes as any municipality can. And again, the Maliseets do not have that language. Okay, so that's who can the tribe tax? The tribes tax. Now, who can the states tax? The second taxing entity. When we're talking about tribes and tribal members under default federal Indian law on tribal land, here again, it matters where the activity resulting in the taxation takes place. So on tribal land, categorically, states are not permitted to tax tribes or tribal members for activities that occur on tribal land or property located within or on tribal land. So this includes sales tax, income tax, and property tax. And determining whether the tax is categorically barred depends on the legal incidence of taxation, not the economic incidence. Please don't ask me too many questions about that. When the legal incidence of the state falls on the tribe or its members, it is not valid. And we could get into that. I'll need help if we do, but that gets into some complications, as you might imagine. Non-tribal lands, states may tax activities and lands of tribes and tribal members wholly outside of Indian country. So if a tribal member is engaged in something that would result in a tax outside of tribal land, that's fair game. Income earned by tribes and tribal members outside of Indian country is subject to tax. So that's fairly straightforward. Now, under the implementing act, with certain exceptions, the main tribes and their members, and in fact all tribes and their members, are liable for payment of all other taxes and fees to the same extent as any person or entity in the state. So the state can tax. When the Passamaquoddy tribes and Penobscot nations act in their business capacity, they are deemed under the implementing act as acting as a business corporation, so a business entity, and are taxed as such. When they act in their governmental capacity, they are exempt from taxes, and that is the same exemption would apply to any municipality in the state. And again, there's no language here as regards to Maliseets. Property taxes are a little different. The Penobscot Nation and the Passamaquoddy tribe shall make payments in lieu of taxes called pilots on all real or personal property within the respective Indian territory. So that's its own thing. And the Maliseet bands also is required to make pilots on their land. Okay. When a text, I'm just going to go back to default federal Indian law for a minute. So when an activity is taxed falls within and without Indian country, taxes are supposed to be prorated in order to be valid. So taxes on income that is earned inside and outside of Indian country by tribal members is supposed to be prorated so that only the income earned outside Indian country is taxed, so people aren't double taxed. And taxes on income earned inside Indian country by tribal members residing outside of Indian country are valid taxes. So usually there's specific questions that come up around excise taxes for cars. So those generally are not supposed to be imposed on tribal members living on tribal land. and the residence of the vehicle owner is supposed to control, even if you drive that vehicle off tribal land. There's some miscellaneous provisions in the Implementing Act as regard excise taxes affecting tribes. So there's language that says excise taxes on watercraft owned by residents of reservations are supposed to be paid to tribes. And there's also another provision to return property taxes that are assessed on parcels in Indian Township to the tribe from the Unorganized Territory Education and Services Fund. There's also a provision that we're supposed to return sales tax collected on Passamaquoddy reservations to the tribe. All right. To get more complicated, non-tribal citizens, federal Indian law on tribal land. So state taxes where the legal incidence of taxation falls on non-members in Indian country are valid unless they're preempted by federal law or if the state's tax would interfere with the tribe's ability to exercise sovereign functions. And there's some language in case law that gets deeper into this. I won't read it for fear of making people's heads spin, including my own. But it has to do, this gets very much into reviewing the specific situation that somebody is in. It's very case specific. The Implementing Act is simple. The state's power to tax non-tribal citizens is not affected. So that's taxation, and it does, there's a fair amount of case law here. There's a fair amount of case-by-case determinations here. There can be some complicated situations that involve combinations of living one place, working another place, having a spouse who lives one place, working another place. Whether you're acting as a tribe, whether you're acting as a business, it gets complicated really quickly. And so what the task force recommendations here were to essentially default to federal Indian law as regards taxation, to make it simple. And that would be taxation for property tax, sales tax, income tax, to default to the tenets of federal Indian law. Now I will stop and first let people correct me or clarify or add to what I've said here. Mr. Albright.
Thank you, Sam. That was really helpful. I appreciate you walking through that. Some of the specifics do get kind of thorny. I wanted to, hopefully for the benefit of the committee, just make a few very high level kind of starting point comments. Because I think if you start here, sort of the basic assumptions, it's good to keep in the back of your head. Because if you try to understand the minutia of each type of tax, it can be difficult. If you're talking about state taxation of a tribe, tribal members, tribal member-owned businesses, the default in federal Indian law is that if the tribal members are on the reservation or if they're on their trust lands, state can't tax. Okay, it's very black and white. Every single time a tribal member, tribal business goes off the reservation, they are subject to all taxes that the state imposes on anybody. Okay, once you leave the reservation boundaries, once you leave your trust lands, you're sort of, there is no Indian, non-Indian anymore. Everyone pays the same taxes. So that immunity from taxation is only on those reservation lands or trust lands for a tribal member. The complexity, I think, oftentimes is more on the side of the taxation of non-Indians. When non-Indians are on tribal lands, and this is just a very kind of high level because there is wrinkles here, there's pretty much concurrent jurisdiction. So, you know, if you're a non-Indian who goes on to the Penobscot Reservation, to a Penobscot business to buy something, the Penobscot government has the right to tax you. But the state of Maine also has a claim of authority to tax you. So there you have sort of double taxation, which is an issue that tends to, can lead to conflict, but increasingly state and local governments and tribes are reaching agreement to avoid those sorts of, double taxation conflicts, right? Because every government wants to generate revenues to support its programs. So for me, it's really helpful to kind of just have that basic starting point, which is tribes and tribal members in Indian country, state can't tax them. If it's non-Indians, then both the tribe and the state have sort of a claim of tax authority. So I just kind of wanted to hammer that basic point home for folks. It's easy to gloss over when you see all the details.
Thank you. What questions? Representative Hagan.
So let me get this correct. If I'm a non-native on native land with a business, bookstore or whatever, I can be taxed by the tribe and the state. So double taxed, same kind of thing.
That's right. And that's what the tribes don't want. But like Corey was saying, the tribes want to, like any government, want to tax whoever's on their lands and doing activities, and they can. The question here is really about when it gets to have some authority. And the state typically only gets to have authority over non-Indians only in certain circumstances. So yeah, you would be double taxed, which is why it's so hard for tribes to recruit non-Indian businesses to their lands.
Thank you.
Senator Sanborn.
Thanks. So in Maine, municipalities can't charge sales tax. So does that mean that under current Maine law, the tribes, can't charge sales tax either under current law?
Wonder if AG Pat Wharton.
Yeah, so let's let if Ms. Pat Wharton can answer it, because what Corey and Mr. Albright and I are talking about is general federal Indian law. But it is a little more complicated under the implementing act. And yeah, I'll defer to Ms. Pat Wharton.
Hi, apologies. So yes, that is the case. So just right now, how municipalities cannot enact their own sales tax under existing state law, that would be the same for the tribes in Maine.
Thank you.
What other questions or comments do members have? Mr. Albright.
Thanks, Sam. I just wanted to, and without going too far into this, I just wanted to put kind of a brief asterisk on Ms. Pat Wharton's comment. And that is that the tribes can't tax as municipalities pursuant to that provision. So in their capacity as a municipality under the language that Sam has here, they may not be able to impose that tax. Whether or not as a federally recognized tribal government, they have the sovereign authority to impose a tax, that is a separate question. And that may be one where there's disagreements, but I just wanted to flag that. Tribal powers don't stem from the Maine Implementing Act. Tribal powers are pre-existing. So the question is whether or not Congress took away a tribe's ability to impose a tax on a sale, which is a separate question from whether or not a tribe can function as a municipality under the Maine revised statutes in imposing a sales tax. So that's probably farther than we need to get today, but I just wanted to put that out there to make sure that that perspective was shared.
Representative Babbitt.
Thank you, Sam. Yeah, I hate to ask this, but I need a clarification on what is the status quo here in Maine. In other words, I'm familiar with pilots, the payment in lieu of taxes, I hear it's kind of unevenly enforced, if that's true. But what I want to try to understand is what is the status quo and how will the tribes be helped if we implement the taxation recommendations of the task force? If you could,
Yeah,
without getting into real weeds here, what are the barriers right now as seen by the tribes?
I could add, as seen by the tribes, and allow Mr. Albright and Ms. Pat Worden to a couple of seconds to gather their thoughts. But at least from the Penobscot Nation view, and what I've heard from the chief there, is what they see as obstacles are a few things. One, the lack of clarity. So under federal Indian law, it's just clearer who's got taxing authority, and it's less clear under the Maine Implementing Act. So you just heard a good example, and I was trying to think it through my mind and waiting to see if Mr. Albright had thoughts. So when Ms. Pat Worden said that tribes as municipalities can't tax under the Maine Implementing Act, that's true. But then you heard Mr. Albright's, and it's on sales tax. So then you heard Mr. Albright's perspective, which is it? Like they can't as municipalities, but does that mean they can't as tribal governments? So it goes back to that fundamental theme of tribes have all inherent rights as sovereigns unless it's restricted by federal law or federal case law. And that's where it gets a little complicated with the Maine Implementing Act, because there are portions of the Maine Implementing Act that say tribes are treated as municipalities, but it's hard to figure out how to, okay, treated as municipalities under state law, but then that's not necessarily taking away their rights as tribal governments. It's basically, kind of how they're treated under state law. So it's there haven't been enough, I would say, activities of the tribes regarding taxation to really sort through these issues. And that's kind of the point I would say on behalf of Penobscot is there's been a chilling effect on economic development in Indian country in Maine, in particular compared to other states, because of this lack of clarity. So I can say, and I think Chief Francis is still on an ambassador, but at least from Penobscot's view, the lack of clarity has created a chilling effect on economic development activities. And that harms not just the Native Americans and the tribal governments, it harms Mainers, because whenever a tribe is doing economic development activities on its land, it's typically employing mostly non-natives, so providing jobs to non-natives, and it's generating revenue that stays there in the local community.
I might, because this is getting into more of a discussion, pass the moderation baton back to the chairs, if that's okay.
Yeah, that's fine. Thanks, Sam. First of all, clarification. Representative Babbage, do you have a second question, or shall we move on to Representative Moriarty?
No, thank you. I did not lower my hand. Thank you very much.
No, that's all right. Just wanted to make sure I'm not missing you. Representative Moriarty, did you have a question?
I did. Thanks, Madam Chair. I can certainly appreciate that the lack of clarification can stifle innovation, development, growth, and all of that. I guess my question is this: if federal Indian law is to apply to Maine's 4 federally recognized tribes, just as it does to hundreds of tribes around the nation, why aren't there definitive answers to all these questions?
Well, I think, Representative, in our mind, and you heard from Mr. Albright, we think federal Indian law is actually significantly clearer on this than the Maine Implementing Act. And so what the Maine tribes want to do is modernize the Maine Implementing Act to be more consistent with federal Indian law, so there is more clarity.
Well, okay, that's an interesting point.
Representative Moriarty, can I just ask you to pause for a moment so we can have someone from the Attorney General's office weigh in as well, just so that we're getting a kind of a more seeing the question from a lot of different angles.
Yeah, this is Chris Taub. So I think from our perspective, we don't think that federal Indian law really provides more clarity than what we have with the settlement acts. I mean, I think as Sam referred to, you know, the leading treatise on federal Indian law is like well over 1,000 pages long, and there are hundreds and hundreds of cases involving issues about federal Indian law, and the U.S. Supreme Court every term decides cases involving federal Indian law. That's not to say that the settlement acts in Maine are models of perfect clarity, and we have had litigation over the interpretation of the settlement acts. I would say in the grand scheme of things, it hasn't been a tremendous amount of litigation. I think probably we've had maybe a dozen cases over the last 40 years that I would consider really sort of significant pieces of litigation involving interpretation of the settlement acts. But I think from our view, just simply incorporating the entire body of federal Indian law is likely to result in more uncertainty, not less. And so I think what you'll be hearing us saying, and sort of what we said last session, is that we think to the extent that the legislature wants to change the relationship between the tribes and the state, we think it's important to do that in a way that provides a lot of clarity. So if there's certain things that the legislature wants to provide to the tribes, or wants to change in terms of the relationship, or change in terms of the jurisdiction, we think it's important to spell that out very clearly in the legislation, rather than simply adopting federal Indian law in all of its sort of nuances and ambiguities and uncertainties. So I think this will be a theme that you'll hear from the Attorney General's office. At the end of the day, I think it's a policy call on the part of the legislature in terms of what you want the relationship between the state and the tribes to be going forward. But I think what you'll hear from our office is that we view our role.
I'm sorry to interrupt you, but we're trying to kind of present this to people in a thematic way so that we can focus on the different elements. And right now we were just talking about the taxation, and it seems to me like you're kind of looking at it from a very broad perspective. Did you want to just comment on the taxation issue that Representative Moriarty asked about?
Well, I mean, I think what I'm saying applies to all of these issues. I think all of the different issues that the committee is going to be grappling with, simply referring to federal Indian law is not going to provide as much clarity as I think you might hope. And so I guess if you want me to sort of limit my comments to federal tax law, there are lots of cases that are still being litigated over what the relative roles of the state and the tribes are when it comes to taxation. So again, if there's specific things that the committee wants to address with respect to taxation, our view is that it would make a lot of sense, and it would avoid future litigation to spell those things out very clearly in the legislation, so there aren't any ambiguities or uncertainties about it.
Yeah, thanks. That's helpful to just, because we're in such a learning process that helps us to really focus on the discrete subjects that we've kind of identified as a way to familiarize ourselves. Representative Moriarty, did you have a follow-up question?
Well, I guess I do, Madam Chair. I see the consensus recommendations number 11 through 16 all propose amending the Implementing Act to recognize federal law with respect to a variety of certain fact-specific situations. So globally, what are we about here? Are we about amending the Implementing Act, or are we focused more about placing federal law in its place?
I'm going to interrupt the responses, and Representative Moriarty, we don't have a bill that we're considering now. We're still just really, this is kind of our way of acquainting the committee with the legal background for the bills that we anticipate will come. So we may have to hold on that question until we're actually in the context of discussing a bill.
And I can easily wait for the answer. Thanks.
Yeah, thank you. Does that make sense to you, Sam?
Yes, and I think also when you're talking about federal Indian law, I think it's hard to say, you can't really write it. Like there's not like you can say federal Indian law, but there's no way to encompass, I think, in a bill, all that is federal Indian law. What I can say is that in the absence of anything else, the default is that canon of law that is federal Indian law. That's probably not helpful, but that's might be the best that I can do right now.
Thank you. I know that Representative Babbage, you may have had your hand up first, but I'm going to recognize Representative Evangelos so that we can get a couple more voices participating in the conversation.
Thank you, Madam Chair. Just, I just have a suggestion, and I'm not being critical, but it's just that we have quite a few new members on the Judiciary Committee, and it's like we needed to go to first grade today, not to graduate school. And you know, we're in graduate school right now. We're into the weeds badly, and you know, I think it, you know, if we can, we're going to need several or more than several of these discussions and meetings. We can't possibly do this in a day, but I think the next time we revisit this, I think we should talk to the new members about what happened last session, what the bipartisan task force votes were, the 18 months of work, so that they can kind of get a grasp of what we did and where we are and why we are where we are, because we weren't, you know, we were basically, we were in the bottom of the ninth inning with the bases loaded with nobody out last August 1st. The Judiciary Committee voted 8-1 to pass this, and one member had an amendment, 3 were absent. So we already had produced a product to go to the floor of the House and Senate. And this is just, I'm speaking for myself, I've been experiencing and studying this for 40 years, and others haven't. I'm sympathetic that we are in the footnotes and the fine print today without giving them the background and history. I would have much preferred hearing from our tribal nations and from Mr. Taub, and just, you know, hear their introductory remarks and try to humanize this a little bit more. But the fine print, the new members aren't ready for this today. And I'm getting a little concerned that we probably should have had a get to know each other humanizing effort. That's all I have to say. Sorry.
No, thank you. That's a good observation, that we do need to make sure that everybody obtains the information we need to do a good job on the bills that are coming before us. And I'll take that to heart. I know we did have some orientation sessions, but to your point, I do think that more information sharing is needed. Thank you for raising that. Sam?
Yeah, I just wanted to also say, I recognize that it is kind of like going to graduate school without doing the first work. I am very, very happy to sit down, I guess, virtually with any of the new members or the older members to just talk through the history and to go through the task force report to help folks out. If folks would rather do that on a more individual basis, I am certainly available to do that.
And if Senator Carney, if I may follow up, Sam, I didn't mean anything personal regarding the great work. I've always complimented you on your great work, but you're the professor today, and many of us are in first and second grade. And I just thought, you know, this is nothing against your presentation. I don't want you to take that personally. It's just, I want to make sure we build up a knowledge base so that then when you're referencing all of these very, very specific and difficult issues, people will have a basis for understanding them. That's all. But I always value your work.
Thank you. But again, if anybody would like me to sit down with them and go through the task force work and the recommendations, I'm very happy to do that. to me an email.
Yeah, Sam, just to follow up on that's a really kind offer. I think that perhaps what we need to do is to come to a decision about what would be helpful to share with the group as a whole, and maybe poll the members, because I think people are in very different places as to what they find their needs for information are. But I would like us to be kind of, as a group, hearing all of the information together in a setting where we can ask and answer questions. I do think this was a very helpful start. But again, maybe, I guess at this point, I would ask you, Sam, did you have other aspects of the presentation prepared today that we should move on to? And then perhaps we can conclude with a conversation about what next steps would be helpful to the committee, again, as far as laying a foundation for the work that we feel is coming to us.
Madam Chair, may I ask an elementary question before we leave taxation?
Sure.
If the new members are in the first grade, I've been studying this for a couple of years, and I'm in the second grade. So this is an early elementary question. I understand that these tax provisions, I do think the federal law is fairly concrete with its tax provisions, and maybe that's rather than simple. Maybe we mean declarative, but I'm starting to understand that this would have important ramifications for economic development on trust land and things of that sort. What I don't understand is, as far as Pleasant Point and Indian Township and Penobscot Island and the Maliseet jurisdiction in Holton, people that live on those lands, how would their tax situation change with these? Not expansion into trust and all of that, but how about the lives of people? I don't understand to the point that they are taxed now. I don't believe that those communities like Old Town and Eastport, Princeton, they don't charge property taxes, do they, to the Indian lands? So I'm trying to decide if this has large consequences for the people that actually live on the home base there for each of the tribes.
Yeah, and that's another kind of challenging question to answer right now, Chris.
It is? Okay.
We know that legislation is coming, but we're not actually doing a hearing on a bill yet. But it would be really helpful if those who are participating in this meeting could describe what the status quo is right now. That would be super helpful to us. Ms. Binney, might you be able to answer that?
I can try, and I can try to ask Ms. Pat Warden to jump in and Mr. Albright, because I feel like they understand this issue under the Maine Implementing Act a little better than I. So I'm trying to rack my brain because it's been a little while since I've looked at the specifics. But my understanding, I'm trying to remember, income tax is one of the things. And I believe Ms. Pat Warden, under the Maine Implementing Act, that Indians living and working on the reservations do still pay state income tax. Is that correct?
Yes, that's correct. Although I think there is an exception to the extent that their income derives from settlement fund amounts.
So that's one of the big things that would benefit the tribal members. So under federal Indian law, Native Americans who live and work, so they generate their income on Indian lands, don't pay state income taxes. And that is generally because the tribe will have some sort of, they don't like to call it tax, but a fee. So it's really about, the government that provides the services. So if you live and work on Indian lands, there's an assumption that that government is the government that's providing you sort of those services. And so the taxes or fees go to that government. That's the rule under federal Indian law. Under the Maine Implementing Act, those Native Americans who work and live on tribal lands still pay an income tax to the state. And so it's not like it's a benefit so much to the members in that they would probably still be charged some sort of tax. But the tax that they get charged would go directly back into services to their own community. So the tribal government services, the roads, the light poles, the schools, the sidewalks, that would be more revenue to help benefit tribal government programs, healing and wellness courts, drug prevention programs, substance abuse, things like that.
Thank you. Did Mr. Albright or Ms. Pat Warden want to weigh in as well?
I mean, I think there's two questions there that I think the taxation committee dealt with in the last legislative session. And that is, what are going to be the impacts to tribal members themselves and the tribe? And then what are the impacts to the state? The current impacts and then any in terms of revenue forecasting. So there's, I think, maybe two concepts there. But I think Ms. Binney spoke well to the interests of tribes and the tribal members.
Thanks. Mr. Albright, did you have anything to add, or are you all set?
Thank you, Madam Chair. No, I would just say in addition to the income tax point that Ms. Binney made, the same would be true for a sales tax. If the tribe has businesses on tribal territory, tribal members have businesses on the territory, then if you're a tribal member and you're shopping there, you're not having to pay whatever tax is being imposed on that transaction. At least, not a state tax that's imposed on that transaction. You'd be paying a tribal tax. Right now, of course, the tribes can't add a tax on top of the state tax because their own people would be paying double taxes, which doesn't serve anyone. So yeah, that's all. Thank you very much.
And so you're saying regarding the sales tax, I believe in the presentation you said that sales taxes would be returned to the tribes if collected on tribal land. But that's not happening currently in Maine.
It doesn't happen for the Maliseets.
Okay, thanks. Thank you. Thank you very much. I was asking specifically about how this would affect tribal members. Thank you. That's good.
Thanks, Representative Babbage. Sam, I'll just reach out to you again with the question. Did you have other aspects of this session that you'd like us to move on to?
I have many charts, but it may be that we have done enough charts for today. I could move on to civil jurisdiction generally. That gets even more complicated. If folks would prefer to let some of this marinate for a little bit, or maybe redirect, I will leave that to you, Senator.
Was civil jurisdiction the last component you were prepared to present today?
So we had thought that, in terms of we wanted to get through tax and land, and we had left civil jurisdiction as we could get started. We probably wouldn't get through it though, because it is pretty lengthy. So we had kind of left that open as to whether we would get through that or not, or start it or not.
Okay, well, I think what I'll do is just take an informal poll among committee members as to whether we could take a 5-minute break and then do perhaps an hour on civil jurisdiction, or we could segue into a conversation of what would be most helpful to the members of the committee. So I'm going to ask everybody, and Lois, Representative Recca, did you have a specific question about the taxation, or?
Sorry, I had a broad question that is more in line with what you just moments ago suggested. So when we get back,
Yeah, I'm going to take a little informal poll among committee members. So I'm going to put down some hands right now and just ask if you can use your mechanical raise hand function, committee members, if you would like to take a 5-minute break and then hear about the civil jurisdiction please raise your hands and keep them raised till I can count who wants to move on.
Oh.
Okay, and Representative Downs, is your raise hand not working?
Is this a vote on the break or on moving on?
It's kind of both, because if we're not going to, all right, good point. Let's do this. We have been going for more than 2 hours. Let's take a 5-minute break. We will return at 3:20. And at that point, we will take up the question of whether we move on to civil jurisdiction or whether we talk about what next steps will be.
And
So-
then, Madam Chair, if I may offer a suggestion, having listened to this and to Mr. Evangelo's comment for the new members, I also wonder if something for the members to think about is, should the lawyers and the Attorney General's office, in the meantime, for the next time the committee meets, put together some concrete examples under taxation and civil jurisdiction that help sort through some of the issues and complexities, like, so it's easier to maybe wrap your head around.
Great. We will. Okay, so let's take all of that up at 3:20, everyone. And remember, we are still live streaming, even though we're not sitting in front of our devices. So please mute and stop your video until 3:20. Thanks, everybody. Everybody feeling a little better after a much needed 5-minute break? Representative Babbage, could you lower your hand, please, just so
Oh,
that we can start?
sorry, I've got it behind.
Here? Actually, I got
I
it.
can do it. I got it. I did it.
Okay, awesome. And a
I was
couple,
looking at my
it's sometimes I think that, Chris, I'm like moving on my end to put down your hand, and you're moving to put it down at the same time, and we inadvertently, one of us puts it back up because we're turning it on and off simultaneously. Let's give the committee members just a couple more minutes to rejoin our meeting, and then we'll talk about where we go from here. See, I just checking in with Senator Sanborn and Representative Poirier and Representative Newell. Are you all in the meeting or not quite back yet? Okay.
Sorry, I'm here.
That's all right. I just checking in to make sure, because this is it's an important decision about where we go from here. So at this point, the question before the committee is, oh, Representative Evangelist, did you want to make a comment before I ask the question? No, your hand is up. I just didn't know if that was.
No, I wanted to make a comment after you spoke.
Okay. All right. I'm just going to put, because I'm going to ask people to raise their hands, so I don't want you to kind of inadvertently vote. So I'm going to put your hand down for a moment. So at this point, the question for the committee is, do we want to move on to civil jurisdiction right now, or would we like to put that on hold until another meeting time, and also engage in perhaps a brief conversation about how we can most helpfully take on that subject matter? So for all of those who want to not move on to civil jurisdiction at this time, but take that up later, perhaps with a little bit more of a conversation about how we can effectively address it. If that is your position, please use your raise hand function now, and then I'll call for those folks who want to keep going. So it looks like there's a group of at least 8 of us. Oh, and I see Representative Harnett's actual hand is raised. So it looks like that there are quite a number of us who prefer to not move on to civil jurisdiction right now, and to take some time to talk about how we're going to take on that aspect of the presentation. So I appreciate everybody weighing in on that. And now I'll ask, let's all lower our hands, because I know that Representative Evangelos had a question, and perhaps others. So if you have a specific question or comment, please keep your hand raised or re-raise it, and I will call on folks as they appear. So go ahead, Representative Evangelos, and then Representative Reckitt.
Okay, thank you, Madam Chair. So roughly 18 months ago, because we were meeting in person, and I know Representative Harnett joined me in these meetings, but I wasn't a member of the task force, but I attended the meetings. And, you know, we all got to know each other, and that's where the trust came from. And, you know, Chief Francis and Chief Sabattis and Ambassador Dana are all here today. But, you know, we're not sharing with them. We're not seeing their faces. We're not hearing, you know, their vision. And, you know, I'm only concerned because, you know, I haven't done the count, but I think we have 5 or 6 new members. And, you know, people like Representative Harnett and myself had the advantage of 18 months of experience in relationship with these good people. And it all starts with, you know, developing trust with each other and hearing their stories, and quite frankly, hearing the tragedy of the state's relationship with our nations. that's how we came about getting these unanimous or near unanimous bipartisan reports. So, and I'm not being critical. I just think that the next meeting we have, we should start with the human part of it and hear from the chiefs and their representatives and the ambassador, so that, we just all get comfortable with each other again. I have that comfort level because we worked together. We sat next to each other. We joked around together. This Zoom stuff's tough. And I haven't heard from, I think Ambassador Dana may have spoken very briefly. I'm not sure, but I know the two chiefs haven't. And I just think that we have to have an orientation meeting that humanizes this, so we get to know each other. We understand where the nations are coming from, and certainly an opportunity for the Attorney General's office and the governor's representative to, tell us what their feelings are, and just hear everyone's vision, because we put a remarkable product together, and it only happened because we met face to face all those times. So I'm just, this is absent of that. We're in law school 101, and if I'm lost, and I'm not lost, but if I'm lost, others must be. It's difficult stuff to understand. So I think we need to get to know each other in a meeting. Unfortunately, it's the Zoom stuff, but I mean, that's my feeling. I'll let the others weigh in.
Yeah, thank you for sharing that, Representative Evangelos. Representative Reckitt?
Yeah, I have a somewhat similar feeling in the sense that what I really want to know and to hear and to feel, which speaks to Representative Evangelos's point, is the broad perspective of the tribes and their representatives, as well as the broad perspective of those of us who are citizen legislators of the state of Maine. What all of us, what at this moment anyway, is our vision of what would be fair, what would be a fix, what would take back some of the wrongs, how can we move forward together? And that's what I'm not, I appreciate the, my understanding, and I own a copy of Indian law, and I've tried to read it, and I've read a lot of the stuff, and I still learn every time I hear anymore. But I think that what I need is to know what is everybody's perspective. And I understand why particularly the tribal representatives may not feel safe to share that quite as easily as perhaps I might. And I don't want that to be. And I understand why it wasn't when the task force was working. But to me, it's what's central is what really is in the heart, in the minds of the people who are living here in the tribes or their representatives, whoever, as well as our perspective and response, that we can do this whole thing together. I think it's so important. I was so disappointed when we had to go home, and we were on the verge of doing, I thought something really quite extraordinary. So I think I'm just going to shut up, but that's sort of my problem.
Thank you for sharing that. Senator Sanborn?
So speaking as a new member of the committee, although also one who has gone to law school, so maybe I'm comfortable in the law 101 world that we've been in, but this is also not my first effort to start to wrap my head around this issue. As soon as I was appointed to judiciary, I knew that I wanted to reach out and get myself educated on this. I had a good meeting with some folks from the tribes more than a month ago now, and have started to build that knowledge base and that set of information. So just speaking as for myself and one new member of the committee, I think it's helpful to come at this from a lot of different perspectives, and to understand the foundational law aspects of it is part of it. the understanding the work that was already done, and I have no interest in reinventing the wheel. I don't think we should try and have another whole task force. That's been done and the work was there, and we just need to wrap our heads around it, be able to pick it up and move it forward. And so I think this was helpful, and I'm coming at it from with a legal background, so I found it very, very interesting. But let's not, think that the only things that we're doing are the things that happen, on this Zoom forum, and that we can't get ourselves smart outside of this setting either, either on paper or through discussions, that we would be having in the halls, but now we can have separately, as we set them up.
Thank you, Senator Sanborn. Do other committee members want to weigh in on how you're feeling? I can share how I'm feeling. I kind of agree with everyone. My concern is that as a committee, we could do, we can educate ourselves, and we can have bill hearings where we really consider policy changes that we're going to make through amending our laws. And but you're right, it needs to be informed by more than just the kind of the law 101 exercises. Let me recognize Representative Hagan before we move forward.
I apologize. I closed my lid and then I lost the link, and so I just came in. I very much apologize. I think that this stuff is critically very important, this material, and I think we have some new people that, in my way of thinking, we need to go and do a very deep examination of everything again, the way it happened before, so that we can get on the correct side of all of the issues that are involved here to do the right thing for the indigenous peoples of Maine and the people of Maine. So I having missed most of what just happened, I would love to go from first grade to second grade all the way to my doctorate degree, and do our due diligence and really, really get deeply into every single recommendation as we have been doing. And we have time to do that, and that would be where I'm at. Thank you.
Thank you. Representative Harnett.
Thank you, Madam Chair. This morning, for those of you who were able to be there, we sat through a pretty intense 2.5-hour discussion talking about indigent legal services. And we went through a lot of nuts and bolts stuff. We talked about the Constitution. We talked about laws. We talked about numbers of cases, numbers of judges, numbers of attorneys. And towards the very end, one of the commissioners, Commissioner Cummins, brought it back to, let's talk about the human beings involved. Let's talk about somebody who might be unjustly convicted and is incarcerated in a county jail or a state prison right now. And I think we need to talk about all those things. I'm a lawyer by trade. I went to law school, so I can sit and listen to the law 101, and that's critically important. I don't think what's being suggested here is to do the entire task force over again, but hearing about the law, even from the tribal attorneys who are advocates for the tribes, doesn't educate us about the human beings that are affected by the work we're going to do moving forward. So although I've worked a lot with the tribes, both in the Attorney General's office and in my time in judiciary, I don't think we can do our job without understanding the human aspect of what we're talking about. So I support setting aside some time to learn that. That doesn't shut out the representatives for the state or for the governor's office. I think it's just a necessary piece of education for new members on the committee, new members in the legislature, and even returning members. I support that approach.
Thank you, Representative Harnett. At this point, I think it's pretty clear that we need to spend a little time thinking about the most helpful next steps that we can take, and taking into account everybody's comments. And so we will not move on to a deep dive into the civil jurisdiction issue today. This has been, I know that we received a lot of information today. It has been a really good start, and has also oriented us to help us understand what's missing from the picture that we have right now. And so we will take that under consideration. And I would ask that everybody who is participating in this committee, particularly committee members, please email the chairs, Tom and I, with your suggestions, so that we can make sure that we're meeting the needs of the committee as a whole. And then for all of the participants today, again, your contributions were really excellent, and we actually wish that we need to hear more from each one of you. I know, please reach out to us, and we will reach out to you for your suggestions about how we can really effectively present everything that the committee needs to know to move forward with the legislation that we expect to have come before our committee. Representative Harnett, do you have any final remarks before we end today's committee meeting?
I would just reemphasize your point that please, committee members, because sometimes it's not easy to talk on these forums, although we will have to, email us concerns and suggestions about how we can help put you in the best position to make very important decisions with a knowledge base that you think is necessary to make those in a meaningful way.
Yeah, and just following up on that, Representative Harnett, to the committee members, we of course are going to have a hearing on the bills that come before us, and we'll really have an opportunity to hear from everybody on this call, the representatives of the tribes and others who can speak very pointedly to the specific recommendations in that legislation, so that we get a really thorough, deep understanding of what's laying before us as a committee. So at that, I think we will conclude our meeting for today. Sam, thank you so much for all of your hard work and your presentation today. We really appreciate all of your efforts, and you get kudos for being an excellent teacher. Thank you very much. So committee members, we will meet again tomorrow morning, and I'm checking our schedule. We will start tomorrow morning at 10 a.m. with a confirmation hearing of Sarah Medina of Dixmont for appointment to the Maine Indian Tribal State Commission. So see you all tomorrow morning at 10 o'clock. Thank you.
Thank you, everyone. Appreciate it.